Warning. You're now entering a stream that isn't suitable for everyone. Be warned that this channel will have swearing, singing, sexual innuendos and lots of jokes that could easily offend. It is advised that you must be a little bit weird yourself to enjoy this channel, as those that thrive and enjoy the stream are weird in their own little ways. The chat is called El Chatty and is a wonderful community. It really is. However, again, it might not be for everyone. We want to hear everyone's opinion, no matter what it is. We encourage debate as long as it's done respectfully. If you're easily offended or don't like differing views, then again, this channel is not for you. By entering this stream you do so at your own risk. If you want to try it out, that's absolutely fine, but if you don't like it, no need to announce your departure, you can just leave quietly, as this isn't an airport.
Hello everyone, how are we people? Hope you're all doing well out there. I was sat here for about 20 minutes just going, I can't go live until Sarah P tells me to go live, so I'm just going to have to wait. So I waited until the time and I am live. So here we go everyone. Welcome everyone, thank you for joining. Please hit the like, subscribe, notification bell on the way in. And also if you'd like to support the channel, the best way to do so is through PayPal and buy me a coffee. So there we are. Afternoon to you, Bagdaza. How are you, son? Thank you for the message this morning as well with the pictures of Tatars. There you go. Afternoon, Sarah P. Morning, Delan. Morning to you, Sarah P. Hope you're doing well. Hello, Rhonda. Okay, she's not here, so I'll say hello to her later on as well. Let's go. How are we doing, Marky? Hope you're all well. Dan, good day, mate. How are we? Hope you're doing well, Dan. Nice to see you again, buddy. So, Katie, how are you? Nice to see you, my darling. Where we at here now? Is I'm missing anybody? Whoa, I think I've got every. Hey, Dave, our favourite Dave. How are you, sir? Nice to see you, buddy. Hope you're doing well. I've got the Stefan Diggs trial. I'll be covering that on the other channel once this is all done. Well, it might be today, it might be tomorrow. Bear with me, everybody. Bear with me. What else we got here? To be fair, you don't listen much and do what you want. I only listen to you. What can I say? I only listen to you, Sarah P. Hello, Lady Di. How are you, my darling? Nice to see you. Good to see you. I got grace. I got a little bit of grace. Not much, but I got a bit. Yeah, hope you had fun on Saturday with bananas. Lady that reminded me, Sarah P was playing with bananas. I don't know what she was doing with the bananas or where she was sticking them. I don't know, but I hope you had fun, Sarah P. So I have got the court. It's ready. I just obviously I remove it for now. They've gone through all the jury instructions. Everything's done, completed. They are just making amendments now. Making some amendments to it. So the prosecution put them together. Once they're done, we'll be starting. Hello, Hot Mama. How are you? Nice to see you, Josie. So there is no rebuttal witness today. The state did not put any rebuttal witnesses on, but there will be go straight into closings. So I don't know how long closings are. I do know the jury are there ready. So once the new packet of jury instructions are completed, and there's like loads of it apparently, then they're going to go into closing arguments. So I have it all ready for us here. So the plan is then to leave this stream up so that we've got the stream together. I need to go to my other laptop then and make sure that I'm in that one. And then I'm just going to leave this one up. I'm going to leave it and leave it up. And what do I need to open the laptop? I don't know. I think I do. Oh, I don't know. We'll see. But we've got the Ohio one that's currently ongoing. The state have got, I believe, that maybe their last witness on the stand right now. So we'll go and watch that. But I'm not closing this stream down. This will just be a verdict watch stream. So yeah, I think I do need to go to my other laptop and put this one on that one so that it doesn't shut down. I think. I don't actually know. We'll have to work something out. But anyway, there'll be another frigging stream. And then, depending on what happens today, Stefan Diggs' trial is happening today. They are selecting juries. Sorry, they're selecting the jury this morning. And there's going to be 6 jurors in that one, not 12, 6 jurors for Stefan Diggs. So it'll probably be a couple of days. Apparently, the state, I think, have got 2 witnesses, the victim and a police officer, and then Diggs, I think, is going to put everybody that was in the house on the stand, maybe testify himself, I don't know. So I might be zooming that tonight, or it'll be tomorrow, and we'll just catch up, zoom everything from 8 o'clock. I will state on record now, so that you've all heard me. If this guy right here says anything about Stefan Diggs' trial, then I am banning him for a day. I am banning you, Dave, for a day if you say anything about the Stefan Diggs trial. So, pre-warning, Dave, I love you, but you'll be banned for a day if you say anything about Stefan Diggs, because I know you're going to be watching it, but I'm going to cover it later on the sports channel, that one is. So, fair, I think that's fair to give him that warning. And just, I do love Dave, but he could be a pain in the fucking ass sometimes with his spoilers. So, no spoilers. David, I still love you, but I think a bit of me wants him to spoil something so I can ban him for a day. Missed it as well, Katie. Lady Di, lovely time. What was it? Patriots are going to be out of a good player. You see, he's starting already. We'll see. We'll see what happens with it, Dave. But that's going to be on Sports Channel, Dave. So we'll leave that for later on. I will stream late tonight if I have to. Or we might, because I don't know when the verdict's going to come back in for this one. I don't know what's going to happen with the Ohio trial either. So, so we'll just have to see. Me, don't act all innocent now, Dave. As you can see here, oops, the court still isn't in, so so there you go. I'll leave it up for now anyways, just so you can see it. So yeah, so bear with me today, people. There might be some mess ups. By all means, do not blame the mods for that. Obviously, you know, it'll be my mess. Wink, wink. We don't blame the mods for anything here, you know. So it'll be fully my fault if anything goes wrong today. If you believe that, then you believe anything. Do you know what I mean? Because I am perfect. Right. Come on, court. As I say, they're all ready. Just, you know, may the 4th be with you. Yes. I agree, Dan. I don't follow. I don't follow baseball, to be quite honest with you. I have watched a few games. I just don't know. I never got into it, you know. So yeah, RFP. I think everyone knows I'm lying. So you know, Bex ain't here. No, Bex is never here. I will say this though. I'm chafed up today. My thighs are a little bit red. My thighs were clapping last night. This morning, sorry. I walked just over 7 miles today. I did about 7.2 yesterday, 7.1 miles today, and Saturday about 5.5 miles Saturday. So I got this hill next to me, right? Bypass is for the cars and stuff. I'm not sure if you've seen it, but I remember saying a few months ago, I was walking down it from the gym, I was like, out of breath and said, oh, this hill's a bitch walking down this. And one day, I had no day soon. I hope one day I'll be able to walk up this, but it won't be for a long time. Well, I did it yesterday, which is like, whoa, that was huge for me. And I did it today as well. And I walked up another hill on Saturday as well. So I'm very proud of myself. So, but my thighs are very chafed. That's the only problem. But yes, I have been really doing well with the walking. I'm happy with how it's been going. I've tried to trot a few times, but I'm still a bit too big to do that. So I need to lose a little bit more weight before I start to do a hot mama Josie, start doing marathons and stuff, So thank you, Sarah P. Thank you, my darling. So yeah, that's why I don't want to stream too late tonight because I want to stream to. I don't. Who cares anyway? Doesn't matter. We'll sort something out. I watched ice hockey, Bad Dazzler, for the first time when I was in Boston, and it was really, really good. I enjoyed it. I didn't really understand it, but it was good. Have you tried berberine? What the fuck is that? Berberine. Let me Google it. Berberine. Berberine. What is berberine? It's a natural plant alkaloid with potential benefits for blood sugar regulation, cholesterol management, inflammation, and gut health. More research is needed. No, I've never heard of it before. Never heard of it. I take vitamin D, and so my day is I'm going to try and eat healthier next week onwards because I eat too much bread. So tonight I'm going to have egg and salad cream sandwiches. So I eat too much of that bread. So I'm going to switch to pasta and chicken and stuff next week. Do more of that and a little bit of cheese and stuff because I need it for, fuel. So all I do is I have a coffee and coffee. Oh shit, it's leaking. In the afternoon. I then eat around 7:30 my time, and that's all. And then I make a one of these and one of these, where it's tea with honey. I put honey in it in each one of them. So it is just like bread, that you're correct. But however, I need carbs because if I'm going on like 7-8 mile walks, I need slow released ones, and pasta, potatoes are much better than bread. That's why. That's why. It really helps work. I will look into it. I've never heard of it before, but I will look into it. I got some here. I need to look at the UK version because as the American version. Also, we need to ask the doctor in chat, Sarah P, as well. She is my doctor, so if you got any medical advice, I'm joking. Don't ask Sarah P. Don't ask Sarah P. She'll kill me. I'm joking, Sarah P. I was joking. That much carbs like bread and pasta, etc. There you go. I need to look into it then. I don't know. I know I just eat too much bread. I need sweet carbs, but they say potatoes and pasta are better, and I'll eat more chicken and stuff then, and vegetables and stuff like that. So, hello, Christine Fortunato. How are you? Hope you're doing well, my darling. Sarah gets it. I gotta do it today. No excuses. Hold me to it. Call me fat or something. What? Are you going to the gym today? We will never call you fat here because you're not fat, KD. This is fat. Way! Good morning, Christine. Hope you are well from everybody in the chat. iHerb. Let's have a look at iHerb then. So I asked Badaza, what tablets do you take? He told me Viagra. So I'm not going to take Viagra. He swears by it. He says you get a lot harder if you try Viagra. It's like, I'm hard enough as it is. I don't need, I got muscles. Whoa. Right, ukiherb.com. Verification successful. Thank you. Berberine Advanced. Oh shit, there's loads of them. Yeah, it's too much options here. Too many options here. And why are there so many options? I don't get that. Vegetables. Oh, I don't know. I'll take a look. I'll take a look. But elderly abuse. You know I love you, Dave. You're just a pain in the fucking ass sometimes, that's all. Can't wait to see your bud as a response to that. Get the eye drops, Dylan. You look hard then. You need about 1,200 megs a day. Shit, 1,200? They're all like 1,000. Yeah, 500 or 1,000 they are. So it'd either be 1,000 or 1,500. There's no like 1,200s here. I don't even know what it is. I just trust you, Dan. I'm like, yeah, I'll take them. I don't even know what they are. Like, yeah, I trust Dan from Australia. I do trust the chat, to be fair. Some of you. 500 milligrams. Anyone watch the Kentucky Derby race? No, I didn't, Marky. I didn't. I'll tell you what, I used to, when I was in college, university, I worked one of the Ascot races and stuff. It was brilliant. It was brilliant. And do you know what? I watched the race and I was not far from the track, and oh my days. They run so fast. It's unbelievable. Hello, Bex. Better late than never. I was in Scientology. Oh shit. We're talking about berberine. Berberine. I also did today. You'd be proud of me today, Bex. I did 7 miles yesterday, 7 miles today, up a hill, down a hill. Also put a little bit of salt in my water today, Bex. So my pink crystals that you told me to take, I did put a little bit in. But yeah, we talk about berberine and how much to take and what the benefits are. I don't know. Because that's a bit awkward. Not gonna lie, I can't believe that was the first female trainer to win. I don't even know why. Oh, in the derby. I'm proud. Don't overdo it. I won't. After years bouncing around the vitamin circus, I found berberine. I know it sounds a bit hyped, but the research is there. Best of luck with it. I changed so much for me. Oh, there you go. That's good to know. I will look into it. Do you not take any of the vitamins in that? I take vitamin D's, and I think I take something else. Vitamin C, I think, like zinc and vitamin C. They are edibles, not edibles, but whatever you call gummies. They're gummies. Right. Not gonna like she said something else. You did something else, Katie. Katie said something else I agreed with. What did you say? Oh, here we go. Dave, you are elderly but not abused. We cater to you here. Dave gets catered to more than anybody. More than anybody. I agree with you. I will research berberine then. I'll look into it. So yes, I agree with Katie there. I have no idea what's going on in chat. What else is new? No, neither do I. This is why I just let the people sling it in this chat. In my other chat, that's why I try and keep it on topic, So I get about zinc and B12 for my testicles and some MG at night for my nervous system. You see, this is all new to me. I didn't even know B12 for your testicles and stuff. I do need to look at it. I definitely do vitamin D and vitamin C/zinc gummies. So, but I need to look at more stuff. D Miss American Band. Why the frig has this trial not started? Oh, I know why. Because we're waiting for the verdict sheets. They have added in lesser included and stuff like that. I think the defense wanted a manslaughter one added, but I wasn't listening intently. Is the chat supposed to be on topic? Is that preferred in all channels? So I can't believe I haven't been blocked yet. I think most channels want it on topic, yes. I think I'm not fussy on this one. Do you know what I mean? As you can tell, but lots. So I think the idea behind it is that if you're a new chatter and if you're a new chatter watching a trial, or for instance, watching a trial, it could be off-putting. Is the thing behind it. So, like if you're new to a channel and everyone's got inside jokes and whatever. So that's why some channels are like, no, keep her on topic. I keep her on topic my sports one purely for algorithm reasons. Because if everyone is just chatting about all kinds of shit and whatever, it puts people off. So this one is gone. I mean, this channel's gone in a lot of ways. That's why I personally don't mind it. Talk about whatever you want on this one. I really don't mind. I think everyone's very nice. Most of you are nice in the chat. And I think if anyone new does chat, I think it's good. But I also agree that, keep it on topic is also good. Discussing the actual trial is good because it might get more engagement from people as well. And I think it pushes it out in the algorithm as well. So obviously because Badaza and Dan and everybody's here and they're talking about boobs and testicles, then obviously we don't get pushed out anyway. So that doesn't make much of a difference. That's why I'm trying to avoid it on my sports channel and keep it all on this channel. We have topics. Well, the topic's supposed to be the trial, but I mean, you guys have other topics. Now, we do our own shit. Yes, we do. You are fussy, though. I'm not fussy. As I say, this one I don't care. The other one I do care. The other channel I do actually care. Only because we're at the start of it now. I want to attract more people. And I think that you're all really, really good. It's just some of the topics are risque in this chat. And it does restrict it restricts the advertisers and it restricts how much it gets pushed out. But like I say, I don't really mind on this one, if I'm being honest. Lol, news to me, I need to get my ass off YouTube then. No, I think it's more the bigger channels, most people are discussing the trial, so you get lost in that anyway. So it's not a big deal. I mean, it's more for people starting out, I think, because when you start a new channel, YouTube doesn't know what's going to be. I mean, the YouTube doesn't know who to push it out to. So that's why when you're a new channel, it's important. After you've had a channel for a while, YouTube sort of knows where it's going to push it out. Like my stuff doesn't really get pushed out. I think because of the topics that I discuss, not just a chat, I have to take accountability. I fucked this channel up way before all of you came here. So we would if it started trial, yes. He just keeping this channel going so we don't bother him on the other one. No, I mean, look, I'm fine with you being on the other one, but I prefer if you kept on topic, and I love Badaza. He enjoys sports. He can contribute a lot to sports as long as he doesn't go into the, well, I used Viagra last night, KD, get your tits out, and stuff like that, But I love Badaza. He knows. I've not said anything about boobs for a while. No, you haven't, to be fair. You haven't. You just send them to me personally, privately. It's just all of us together. I get it, pretty much. Okay, I'm a new woman today. I'm going to work out and behave in chat. Don't behave. Don't change where you are in chat. It's fine. As I say, I don't mind it. This is fine. Bex is a sports nut. Is she? I didn't know she was a sports nut. Boo, don't do it, KD. Testing is equal to testosterone, which manages mood, weight management, motivation, and many other things. Look after my balls and the rest of it. So interestingly, I got a endocrine meeting in July. So they wanted me a year and a half ago. They wanted me to I had low testosterone. So they were looking to put me on some gel and stuff. So I had to take gel. But since I've been losing weight and stuff like that, my bloods have got better and stuff like that. So I got another blood test, I think, in June, and then my endocrine meeting is on July, and I hope that it's high enough I don't have to have any aids, like, the gel goes on your arm allegedly. It's something, so it's on your arm, but once you have it, you can't get off it. You have to use it for the rest of your life, and I don't really want to do that, And it lowers your, I think it lowers your sperm count. So if you have it, you can no longer have children. Not that I'm never going to have children, but still. But it does boost your, how you are, your moods and stuff like that. So totally go teams. Go teams. Where does the gel go? I think that's just one of the treatments. Is the gel the one they prefer? But also, it's also one of those things where, like, my father had prostate cancer, so it does increase. If you take the gel on your arm, it does increase the risk of prostate cancer. And I'm obviously at a high risk because of my father, So I'd rather not take it, Go teams, all of them. Ha ha. Bex, part gel, part lube. Arm, not arse, no. Arm. It's on the arm. That one. I'm sure there's other mechanisms as well. Just the one in the UK, what they use is it on the arm. So, Dan, if you rub Ben Gay on your balls, you'll buck like a mule. That's true. There's a shower gel, Bad does mint it is. I forget what it's called, but if you put it downstairs, oh, here we go. It stings. Hang on then. Please look into ball health. There's lots you can do to raise it. There is. Mine have been raised quite significantly, Dan, since I've exercised and food and stuff like that. Happy days. Thank you, Dan. I appreciate you, sir. Right, let's get this here.
For the state's president, defense counsel, and defendant are present. My understanding is y'all are still working on the corrections for the jury instructions.
They've been completed. They're just printing right now. Defense and state
That's
have
fine.
both looked at the changes and approved, and now they're just done.
Very well. All right.
Judge, we do have two issues we could address before going into closing.
All right.
The first is that we had objected during the voir dire about talking about how the defendant sits here, he can get life, talking about his potential sentence. We would move in limine that not be discussed or argued to the jury, as it's improper for the jury to consider the sentence.
Okay. All right, Mr. Wheeler.
Judge, I think the defense is allowed to infer that Mr. Horn is a co-defendant of Mr. Stein, and his sentence would be approximately the same as Mr. Horn's. I am allowed to talk about his exposure, Judge, and certainly the deal he has with the state. To
Mr. Stein?
No, Judge, Mr. Horn.
You can talk about Mr. Horn. You can't talk about punishment for Mr. Stein. I don't think that's proper. Is there anything, is that it? You agree with that?
I do.
Okay. But certainly they can talk about Mr. Horn.
Of course.
So.
Just as long as they don't relate it to Stein.
Yeah, I think you were making the extra step to say, well, whatever Mr. Horn could get, Mr. Stein could get as well. You need to consider that. They can't consider potential punishment of the defendant.
Correct, Judge, that is correct. But I think that the jurors may take whatever inference they may from.
As long as you don't say it.
Yes, sir.
Okay.
That's the rule.
And then the only other thing is we would just ask that the court, there's a courtroom full of people, some here are new probably.
Okay.
That you just give your standard.
Sure. Obviously, this is a courtroom. There are rules of decorum established by an administrative order signed many years ago, still is in place. And so the courtroom is a solemn place where the jurors are expected to be able to do their work without any influence or intimidation or anything or cheering either way. So just understand you have to remain silent, no gesturing, rolling eyes, anything with, putting your hands up in the air or thumbs up, thumbs down, any kind of an indication to the jurors that any kind of communication to them while they are considering the case, obviously. So just, and if you need to have a discussion or talk with anybody in the courtroom, I will tell you, you need to go outside in the hallway, have that discussion, and then come back in. Everybody's been very polite, and so I appreciate that. I just expect that to continue through the closing arguments, as well as, if the jurors come back for a question, or if they end up having a verdict or something like that, the rules are the same throughout until the trial is over. Does everybody understand that? All right, thank you. How long do the state and defense expect their closing arguments to be?
Judge, for the state, for both of ours, between an hour 15 minutes.
Oh, that's fine. Okay. Mr. Wheeler?
I'll take whatever they got, Judge.
Okay. All right. I'm not limiting you. I just want to know for scheduling purposes. It's, we're about 30 minutes later than when I planned on starting. Part of that's because of the jury instruction changes, I think, that were received early this morning. It takes us time to get those done. So I would prefer to have those done earlier over the weekend, but it is what it is. So probably end up doing closings and then maybe let them go to lunch and then come back after lunch, and I will read the jury instructions. So let them begin deliberating. I think that's the way the timing will go based on what y'all are telling me. And again, just for members in the audience too, if you see any jurors at lunch anywhere out in downtown or anywhere else, please do not communicate.
Okay, so again, thank you, Dave, our favorite Dave. Thank you so much for the coffee, my friend. So it looks like we're going to be about an hour and a quarter each, 2.5 hours. If they start before long, it's be 11, 1 o'clock, lunch for an hour, 2 o'clock, and then, So it'll be fine. And I think the jury instructions could be at least half an hour, if not more. So
Up to
72.
okay.
72 pages for jury instructions. 70 friggin' 2.
She had them printed, but they found some more issues, so she had to reprint them.
Let me take a look to see what's happening in the Ohio one. Okay, the Ohio one, the witness has been on there for about an hour, 15 minutes, and is still with the state, so. $72, yes.
And might the jurors have coffee and snacks and everything back there? Thank you so much.
Snacks they didn't count because normally.
That's fine. That's fine. Thank you.
Because I anticipate that we always spend like 15 minutes for her after the council's all,
Okay.
Okay. All right, then we'll be in recess for about 15 minutes. I'll come back in.
Oh my days.
All right.
Oh, so they're not going to start till about 11. It's going to be 11, 12, 1, 1:30, lunch till 2:30, due instruction till about, say, 3:15, and then, oof. Yeah, this is not good, people. This is not good. We will then go to Ohio, and that will be on 1.5 hours. Zoom, 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 zoom. We're going to be zooming on that one. What the hell am I going to do then? What do you mean? What are you going to do? Where are you going? Where are you going, mofo? I don't understand what you're doing. Here she is.
Hippie chick, Marky C, Spacey Stacy, walking those streets all night. You go, ladies and Marky, go have some fun now. Let's go, girls.
Marky's one of the girls. Do you know what I mean? Like, do you know, like, there's some men out there, they're just like one of the girls. Do you know what I mean? That's why I say, let's go, girls, because Marky's a girl. Do you know what I mean? He's not an actual girl, but he's one of the girls, you know? So, you could just see Marky. He's like, hey. Girls love Marky. You just know it, you know? Because of that comment, I will definitely, because of court, just because of that comment, I will definitely fuck off out. What do you mean? I'm here, I'm entertaining you, mofo. What's going on? What I might do is go straight over after this, go straight over and do the Ohio one. And then come back here afterwards and do the closings, as in do the jury instructions, if that makes sense. I don't know. I'm gonna have to think this out. The problem is, me and thinking don't go together, so they don't go together. But yeah, I think once because we got an hour, so might as well start the Ohio trial and then come back. Then leave this up, but on pause. Play the Ohio one, then come back here. Play the jury instructions. Are you doing Stephanie Diggs? No, but I'm doing Stephon Diggs. I am. But my plan is, because this one's so close to finishing, I want to get this one out the way. Do you know what I mean? Ohio, I don't actually give a shit about, but we're in the middle of it. So my Stephon Diggs one is going to be done on my sports channel. So I am probably going to do that. I don't know. I might do it because they're still selecting a jury today, this morning and stuff like that. I don't know when they're actually going to start. So I might just start covering it tomorrow and play day 1 and day 2 tomorrow, if that makes sense. Because then I can skip the break, skip the lunch break and everything, and do that. So I'm definitely playing it. Not Stephanie, exactly the line use your brain if it's in there. Stephanie Diggs, good, because I was going to cheat her. You cheat me every fucking day. No, I'm definitely doing it, but it'll be from behind. But I know they love it from behind, chippy chick. So, you know, so yeah, it'll either be today, tomorrow. As I say, they're choosing the jury today. So the juries will be 6. And not 12. So, which makes it probably gonna, you know, start a little bit sooner. But yeah, I'm definitely covering it. Crap, I can't watch there because I'll destroy that channel. You won't destroy it. What are you talking about? You're always actually, as long as you just, I'm very nice on that channel. So as long as you don't come in and take the piss, you'll be fine. I'm confused now. Just let me. So after the closings are finished, RP, I will start the other one and keep this one up. So, oh, hippie chick definitely cheats me. I know she cheats. I see her in chats. I see her cheating. Mofo she is. Hey, this is why I've been song about Hippie Chick, Lady Di, Spacey Stacy, and Marky, the main cheaters. Mark, I want you to teach Dave the slang. I don't like nice to learn. I am very nice actually on that stream. Hippie Chick. Well, if you see her there who's cheated around, I cheat all the time. I cheat to myself all the time. No, I sometimes cheat to myself because I get bored of streams as well, people. So like I have to stream it for you guys. I get bored and fucking go somewhere else. You say you don't watch the channel, so how you seen the cheating? I'm joking. I'm obviously it was more during like Halloween and stuff. So, but it's no, I don't actually watch any of the channels now. Thank you, Dylan. No worries at all, Sarah P. All good, my darling. Hope everything go. Oh, it's not. You work in a hospital. That's why. Fucking hell. I sometimes go and pop over and see Erica if she's live, but apart from that, I literally don't watch any of the channels. And when it comes to these things, I used to, but not anymore. I do not watch any other channels. Bye. Oh, come on, court. Let's get the mofos out of here. I was hoping that this was going to be done fairly quickly today, so then I could get Ohio out of the way, hopefully get a verdict on this one, and then piss off and do the Stefan Diggs one. So, can't even be loyal to yourself. How the fuck do we believe you are loyal to us? I'm always loyal to you because I'm bloody here. Do you think I want to be here with you, mofos? Taking the piss out of me, being nasty to me, always abusing me. Do you know what I mean? I want to be in a place where people are nice to me, and I never see Sarah P, Lady Di or Bex into the chat. All the other mofos here, I say yes. Oh, Bad Daz is a whore as well. He's a chat whore as well. Bad Daz is one of the worst. I hate other chats. Typically, I never chat. Just listen. Yeah, I even when I go to Erica's, I don't chat. Exactly, Katie. Jinx. Yes, you want to be here. You're into it. Bexa, talk dirty to me in the chat today. You're into it. You love it. You love me. I do have a love-hate relationship with some of you. What was the reason for the recess anyway? I missed. I was making coffee. So I was. They basically what's happening, Dave, is that they printed out a new queue instructions, basically. So I'm going to do that, and they're doing that now, printing it, and then they'll come back on the record. But they have changes to do, basically. So once they come back in probably about 10 minutes or so, we start. But that's the delay, basically. I played it to you. I played it for you. I played it to you. I'm just a whole general. You are. I played it the day for you, Marky. That tells me Marky has a mind like a sieve. He doesn't remember. Let's see if I can find it again. Here we go. I got it here for you, Marky. This is good on. Right, so those of you that don't like this sort of thing, warning. I know you're going to leave. Have a great day to you. Much love to you all. So yeah, I don't get offended. Just don't say anything in chat. Oh my God, this offends me. Well, then the door's that way, So, but yeah, I know it's going to offend some of you, but it is what it is, Right. Let's look here. Where is it gone? Here we go. Oh, that's why I got the wrong one. Okay. Right. Because Sarah P's not here to give me a row. I've got to be careful of Josie. She might be around here somewhere. Now I can't find it. Oh, here we go. Let me put it here.
Happened in 2018. The cement slab is poured in 2016. The body is already there under. That trespasser has nothing to do with this. Well, we know he's not sending the 500 pages.
Sorry, I'm bored. Did you not know, people? Do you not remember this story about Scott? Scott was that? Do you not remember it? When Scott, we were here one night. Oh, I think it was actually Benefield. No, that might not have been. We were doing a long stream, and we were about to finish. I was like, right, I think we're done for the night. I think we're done. We've done like 12 hours or something. Right, thank you, everybody. I thanked everyone for being here. And literally, as I said that, Scott, Scott must have. I remember it. I was like, good night, everybody. And Scott fucking, I must have written the chat. I pressed enter. As I was saying goodbye, and he came up and put a cross-dressing. Well, I'm not going to stop the stream. So we carried on for like a couple more hours talking about cross-dressing. Literally, the timing of it was like, right, good night, everyone. And then he posted it. And I saw my girlfriend, my ex, used to make me dress up. So then we got into the story. So I bring it up nearly every time now for Scott. That's hilarious. I love it. I genuinely do. Scott, I'm so sorry, Scott. Oh, shit. Hang on, I got Larry on the phone. I'll tell my husband to dress in lingerie just to see what he would fucking. I would do it in a heartbeat, so he would as well. Larry. Larry,
Sir.
you are live to tape. We're on stream, okay?
Oh,
So just
hello, everyone.
yeah, we just we are. I've not checked in you all week. I was going to phone you this morning. Then I thought, you know what? We had a break, so I thought, you know what? Let's phone him now and see how he is. But then the trial's going on as well. So, but we still answer the call to you because you're the man.
What's the topic of discussion today?
Well, we're watching this boring trial, okay? So that was bad. But the topic of discussion right this second, I don't take this too far now, right, Larry? But this second is we're talking about Scott McGuinness cross-dressing, his and you would do it. So the scenario is this, right? So you bought your significant other, your girlfriend, right, some lingerie and a corset and like nipple tassels to dress up in and stuff, right? That's what happened here, right? She wears it, you do the business, you get down dirty, you do the business, and then she turns around to you, Larry, and says, right, okay, if you want to have sex again, you now have to wear the lingerie and the corset. Would you do it?
Well, the answer to that is no.
Shut
And
the front door.
and one time I only bought lingerie for a girlfriend once.
Yeah.
And I'll tell you why. Because I went over, it was a Friday night, we had a few drinks, and I said, I gotta go out to my car, I'll be right back.
Yeah.
And I went out to the car, I got the bag, and I came in and I go, honey, will you put this on? So she looked at it, and she goes, absolutely. And she said, she goes into the bedroom, and she's coming out, she put the lingerie on, but you know what else she put on?
What?
A strap on. I go, what exactly are you planning on doing with that? She goes, turn around and find out. I said, fuck you, and I ran out of there.
I didn't expect that. Oh, sorry, Larry. That's not what I was expecting. Oh, fuck, I'm crying. I was not expecting that. Oh, fuck, Larry. That's not where I thought that was going. Oh, fuck, I can imagine you run out of there. Oh. Oh.
And I'm 6'2", 220. I was running like a little bitch.
Oh, I bet.
My ass was all tucked in. I was shaking. Oh my God.
What was her size? Was she huge? Was she tall?
And she's like, "Come back, honey, come back."
Well, was she taller than you or something?
No. She was like 5'7".
Oh, fucking hell. What size was the strap on, though?
Oh, it was a big black one.
Okay, yeah. I can't. Oh, I can't. No, I would have run out as well. You just took that. You took a story about cross-dressing. You just doubled it up, times it by 10. Oh. Because I thought 100% you would. 100% you would. If someone said...
Absolutely not. I don't go for that shit.
Not now. Not with that story, no, but...
Jesus Christ.
I thought...
Nightmares because I just told that story again.
You said it live as well. Everyone sees it on stream. Larry, for fuck's sakes.
I can't even tell that story in front of Tyson.
I can imagine. Well, you told it in front of about 50 people.
Oh, yeah, he looked right at me and go,
Oh, fucking hell, Larry. Well, you've just taken that. Scott McGinnis is really happy right now because he's like, there's levels to this, yeah? Scott came in with a high level. There's no way you can trump that. But hang on, let's call Larry. Next thing you just fucking trump it. Oh.
Okay. Here we go. Sorry, I can't listen to myself. So, no, Lisa Reed is not in chat, people. That was just from the recording, just in case. Right, the court is back.
And there's no way for you to.
Is this the court? They teased us. The court teased us. I thought they were back. They're not back. Get back for good. Take me back. Take me back. Take me back for good. Whatever we say, whatever we do, we didn't mean it. We just love it from behind. Take us back. Take us back. Take us back for good. I need you to clip your laugh and send it to me in a format that I can set as my ringtone. Thanks. Good luck with that. I have no idea how you even do that. So I would not have a Scooby-Dooby-Doo. Where are you? Scooby loves me long time. Scooby-Dooby-Doo, where are we? Mark, I blame the blonde hair. His belly laugh makes me fucking cry. It's amazing. Oh, thank you, everybody. Look it up. The fuck? I'll send you the clip if you want. I'm just not going to fucking... I ain't going to edit it for you. I have no idea how you do any of that stuff. I am not tech savvy. I ain't tech savvy. So here it is. No, I thought we were back. Motherfuckers teased me. Tis me, tis me. Tis me, baby. Tis me, tis me. Right. Let's have a look. A look. Boom, boom. Boom, 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 boom. Boom, boom. Right, I don't know what some of these things are. Do, 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 do. Do, 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 do. Do, 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 do. Wow, 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 wow. Right, Dave, if you're still here, this is Dave Hamburger, not our favourite Dave. Dave Boston's our favourite Dave. Dave Hamburger, if you're still here and you're going to do anything.
Josie and Murph, they aren't as lovely. Fuck around and find out. I'm joking, they're lovely.
Those of you here, welcome everyone, and thank you for joining. Please hit the like, subscribe, and notification bell on the way in. That would be very much appreciated. There are 17 people here and only 13 likes. So please, if you can like the stream, that would be very good. It does help with the algorithm to get stuff out there. And if you would like at all to support the channel, the best way to do so is either through PayPal, especially if you're from the UK, or buy me a coffee. Thanks to Dave Boston, our favourite Dave in Boston, for the coffee earlier on. If you do feel so inclined, that is the best way. They're all pinned up. No, where are they? Down, up or down? They're down in my one. I'm not tech savvy either, Lady Di. I guess I'll look it up. Bex, Google is your friend. I'll try for you, Bex. I know. I didn't even know we could make a ringtone out of anything. So if I could make a ringtone, I'd probably make into Sarah P.
Oh, thank you very much. What's this?
Welcome.
Whale what?
Welcome.
Welcome. I'm sorry, honey.
They're not serving
so
whale
sorry,
semen.
baby.
I've got it. Thank
Or this.
Twinkle, twinkle, little snitch. Mind your own business, you fucking nosy bitch.
So one of those. Or maybe this.
Hippie chick, Marky C, Spacey Stacy, walking those streets all night. You go, ladies and Marky, go have some fun now. Let's go, girls. Erin Hartree drives a bus, yellow bus, yellow bus. Erin Hartree drives a bus all day long. Ole, 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 ole. Erin hack, ole. Erin hack, ole. Let's go, Erin hack, ole. Erin hack, ole.
Hello, Erin Hack. Nice to see you, darling. Hope the holiday is going well for you. Hope you're enjoying yourself there on the beach. Laugh on the beach. Look at you, Hack. Oh! Oh! Come on! Freaking muffos! This has do my head in. This has put all my plans in jeopardy today. The plan of me trying to be nice to everybody today is literally gone out the window now. Because the court is pissing me off, which means I'll be pissing everyone else off. Glad you're enjoying, Hack. I hope everyone is enjoying. I hope Macy's behaving, which I know she is. And I hope Rocky's at home behaving as well. And I'm being looked after, and I know he is. Oh, your niece is there as well. Oh, your whole family's there. I just thought it was you. Public schools, my niece thought we were on the Pacific until last night. Damn public schools. The Minneapolis school. Let me move this one over here so I can cover the logo. Yeah, it's done it. Done it, mate. Done it. They teach nota. Bam, bam, bara, bara, bam, bara, bara, bam. I don't remember what trial are you on about there? The judge, where he goes off on the attorneys. I don't remember that one. Lady Di. Oh, I'm tired. That's what 7 miles does for you. It's my hubby, myself, our kids, and my niece. Oh, she graduated this year, so we brought her. There you go. Happy days. Where's she going to college then? Where's she going? Is she going staying in state or is she going out of state? Because that's always a debate. Carly Gregg. Okay, I don't remember what you're on about, but I do remember that trial. Michigan. Oh, go blue. Go blue. OHIO. Go blue. I need to get my Michigan jersey. I forget where it is. Is in one of these boxes that Michelle and Lisa Reed got me. My Detroit Lions one. I need to get them out. Detroit Lions and Michigan jersey. I'll wear them. I need to do that. That's my mission in the next few days, to get my NFL gear out. Ready. Nursing school. Happy days. I just brought myself a gobble because I am a geographically challenged. Is a gobble the thing that you do with your partner? Gobble, gobble. Lady Di. I don't know. But that's nice of you. That's nice that you're doing that. Here she comes, the other cheating bitch here. Here she is.
Hippie chick, Marky C, Spacey Stacy, walking those streets all night. You go, ladies and Marky, go have some fun now. Let's go, girls.
A priest, a chaplain, and a rabbi walks into a bar. The barman says, "What the fuck is this? Some kind of joke?" No, I don't get that joke. That's gone over my head, Dan. I'm thick with this kind of stuff. That's gone over my head. Spacey Stacy. Her boyfriend's staying in Minnesota. He signed his life away to play football for Minnesota. Oh, that's nice. That's good, though. He gets to play football for his home state. That's good. You'd have to tell us his name, because college football season's about to start. He probably won't start his first season, but I look forward to following his journey. Hippie chick, Bex, Lady Di, boo. Great scene in the state of Florida. In God we trust. And just remember, in Florida, they can go all night and deliberate as well. So I might be fucked with this one. Talking about gobbling, that are pro gobble here, gobble. Sarah P says, I can attest that you do not, in fact, need geography to be in this. Thank God. No. He's on the Twitter. I will send you his Twitter name. Oh, happy days too. I'll follow him for sure. I like to support people that other people know and stuff. It's good. That's a great gift hack. That is a very generous gift of hack, but she's a very generous lady, in fairness to her. She can be a pain in the ass, but overall she's a very generous lady. She's having a blast, Marky. We loved the Pirates show last night. Oh, here we go. Court.
For the record, State's President's Council. Please be seated. I know y'all are still trying to make changes, correct?
Fuck!
Yes, they are being printed again.
Other changes? New changes?
Yes. Not new that we talked, they wanted it, not new that we talked about. They looked them over, approved them, and then found some other things after they were printed.
Okay,
It's
so.
an independent act after every single charge.
Right.
Right.
And I guess the only thing is, I feel like this is unfair to the jurors for waiting back there unnecessarily. That's why I ordered you all to do this over the weekend. Monday morning is not the weekend. So is there any reason why this wasn't done Friday, Saturday, or Sunday? Mr. Montoya?
Judge, you should be looking at me. That was my responsibility.
So is there any reason why?
I had plans this weekend, I couldn't get out of them, and I responded to Ms. Miller. I started last night, but this course was very limited.
Okay. Just understand the inconvenience, the unnecessary wait the jurors are having. So that's why I wanted y'all to do it over the weekend. When I ordered y'all to do that Friday, I wasn't informed that you had plans that would prevent you from doing that. So I relied upon our discussion Friday that these changes would all have been worked on over the weekend rather than this morning. But that being said, it looks like we've got a new packet.
I just have to shuffle in what I'm presenting during my closing. It's very short, but this is the first I've gotten, and I'm doing it very quickly.
That's okay. I understand.
We might go through them while she does that. I've got a packet to make sure that.
So as far as I understand, though, Ms. Wolf wants to insert the independent act instructions that we're going through. Is that what you're talking
Oh,
about?
no, just for her closing. She just is preparing her closing.
I just want to, I'm referencing certain pieces of the.
You're working on your closing.
Yeah, I just want to.
We can do the jury instructions.
Yes, yes.
I'm sorry.
I thought
Okay.
you were gonna close
I understand.
And I just needed a minute. Sorry.
That's okay.
I've got
All right. So we'll go through. You got your packet. All right. Introduction to final instructions. Statement of charge. Introduction to homicide.
No objection.
Count 1, first degree felony murder.
No objection.
Independent act.
No objection.
Aggravation of first degree felony murder by carrying, displaying, or using a firearm.
No objection.
Possession of firearm and discharge causing death.
No objection.
Lesser included crimes.
No objection.
Count 1, lesser included crime, second degree murder.
No objection.
Aggravation of second degree murder by carrying, displaying, or using a firearm.
No objection.
Possession of a firearm and discharge causing death.
No objection.
Principles.
No objection.
Independent act.
No objection.
Count 1, lesser included crime, manslaughter.
No objection.
Principles.
No objection.
Independent act.
No objection.
Aggravation of manslaughter by carrying, displaying, or using a firearm.
No objection.
Count 2, attempted robbery.
No objection.
Possession of a firearm.
No objection.
Principles.
No objection.
Independent act.
No objection.
Lesser included crimes.
No objection.
Count 2, lesser included crime, theft.
No objection.
Principles.
No objection.
Independent act.
No objection.
Lesser included crime, assault.
No objection.
Count 2, lesser included crime, assault. Sorry. That's on page 31. Page 32 is principles.
No objection.
Independent act.
No objection.
Count 3, attempted robbery.
No objection.
Possession of a firearm.
No objection.
Principles.
No objection.
Independent act.
No objection.
Lesser included crimes.
No objection.
Lesser included, count 3, lesser included crime, theft.
No objection.
Principles.
No objection.
Independent act.
No objection.
Count 3, lesser included crime, assault.
No objection.
Principles.
No objection.
Independent act.
No objection.
Count 4, attempted robbery.
No objection.
Possession of a firearm.
No objection.
Principles.
No objection.
Independent act.
No objection.
Lesser included crimes.
No objection.
Count 4, lesser included crime theft.
No objection.
Principles.
No objection.
Independent act.
No objection.
Count 4, lesser included crime.
No objection.
Principles.
No objection.
Independent act.
No objection.
Plea of not guilty, reasonable doubt, and burden of proof.
No objection.
Weighing the evidence.
No objection.
I think in weighing the evidence on page 63, I'm looking for where is the defendant in this case has become a witness.
The next page.
Oh, it is?
54.
Oh, okay. All right, I see it. Never mind. Thank you. Okay. All right. Page 65, rules for deliberations.
No objection.
Cautionary instruction.
No objection.
Verdict.
No objection.
Verdict form.
No objection. No objection.
Okay. Okay, then we have special finding is the first degree felony murder.
No objection.
And special finding is the second degree murder.
No objection.
Special finding is to manslaughter.
No objection.
Special finding is to count 2 attempted robbery.
No objection.
Special finding is to count 3 attempted robbery.
No objection.
Special finding is to count 4 attempted robbery.
No objection.
And single defendant, multiple counts.
No objection.
Legally interlocking counts as to first degree felony murder.
No objection.
And submitting case to the jury.
No objection.
All right. And then I have our alternates as jurors 77 and 29, correct? So at the end of the instructions, I'll make sure they stay here. But those are the 2 that we want that were selected as alternates, correct? From the state and defense. 77 and 29.
Give me 1 second, Jim.
That's okay.
That's correct, John.
Okay.
That's right.
All right. Are we ready to bring the jurors out for closing arguments? Defense ready.
That's right.
All right, so it's 11:15. The state's saying their arguments may take an hour and 15 minutes or so. So we'll probably let you do your beginning closing argument. I'll let them go to lunch and come back and do yours. What?
Judge, they're going to be shorter than me because they're also going to have a rebuttal. So I would ask that we do the state's first opening
Yeah.
closing argument. Allow me to do my closing argument and come back to the rebuttal.
But then That means jurors will not go to lunch until probably 1:15, 1:30.
No, because I won't, if I don't do mine, like the total, we're an hour and 15 minutes for both of ours.
Oh.
If we just do hers and his.
Then we can let them go to lunch.
Right.
Okay, that's fine. I'm sorry. Okay. All right. Is that everybody agreed on that scheduling wise? Okay.
I would ask though, if the closings aren't as long where they need to go to lunch, then I could just do my rebuttal. But I'll let you decide
That's fine too.
time-wise.
Yeah, that's fine
I
too.
would prefer to do it, but if
if
they need to eat.
Yeah, we pushed up against the lunch hour for them now, so I want to make sure at least they haven't had anything to eat yet. So
Unless they have any snacks.
I don't think they have snacks right now.
I didn't put them
Yeah.
after we did deliberation.
So anyway, all right. Are we ready to bring the jury in? Defense ready? All right.
Okay,
Let's
here
bring
we
them in.
go. Oh, this is a nightmare. This is a nightmare. That fucks my whole plans up as well. If they don't do it all now, I might phone the judge and be like, "Hey, listen, you're fucking my time up here. That means I can't go over to the Ohio case now if they're not finishing the rebuttal." Maybe I can. Fuck it. We'll see. Depends what mood I'm in.
Yours entering.
All right. Please be seated. Welcome back, ladies and gentlemen of the jury. By a show of hands, was anyone not able to follow the court's previous instructions about doing any research, looking up anything, or discussing anything about their service as a juror on the case? Seeing no hands, ready to proceed. So, ladies and gentlemen, both the state and the defendant have now rested their case. The attorneys now will present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. You may proceed.
May it please the court, counsel, Mr. Stein, ladies and gentlemen. On March 17th of 2024, Kayla Rincon-Miller was shot and killed during an attempted robbery that targeted both all herself, Luann DeJet, and Emma Wright. That's what this case is about here today. The perpetrators of that robbery arrived in a gray Nissan Pathfinder that was driven by the defendant, Thomas Stein. That vehicle stalked those three girls back and forth on a dark road where those three young women were all alone. Ultimately, that car made a U-turn back, flashing the high beams at the three girls, and immediately the occupants of that vehicle jumped out saying, "Give me your shit." This was a robbery from the moment that happened. Each of those three girls had guns in their faces by their attackers. In moments from those car doors opening, shots rang out and Kayla Rincon-Miller dropped to the ground. The car, filled with all those occupants again, raced away directly back to the home of Thomas Stein. Over the course of the trial, you received as jurors a whole host of evidence. And quite honestly, in this case, it ran the gamut of the type of evidence that jurors can receive in a case. You heard testimony from eyewitnesses, testimony from investigating officers. You saw video evidence, that PowerPoint that put together all of those points of travel, the Hertz tracking, the tower data from cell phones, the license plate readers, the traffic cameras. You heard forensic evidence from the crime scene technician who went to the scene of the crime and collected the evidence. You heard some forensics from Amy Schober, who put together some information from you based on the details of the investigation related to the firearm and the injury to Kayla Rincon-Miller's chest. You also heard from the medical examiner about her expertise and examination of the autopsy that was conducted on Kayla Rincon-Miller. And you also had the benefit of hearing from both of the two charged co-defendants in this case. The court will be giving you a whole series of instructions, and we often refer to it as a packet. But honestly, in this case, it's essentially a book. It's large, it's voluminous, it's going to take a little while to get through them. But as jurors, you will get a copy of that to take back with you. So you don't have to be concerned about taking notes and trying to remember what the law is and the other information provided in those instructions, because not only will the court read it out loud on the record, but you will get a copy of that to bring back into the jury room with you. And as Judge Thompson indicated, the structure of these closing arguments is that the state gets the opportunity to address you first. The defense gets the opportunity to put on a closing argument. And then because the state bears the burden of proof in a criminal case, we get the opportunity to address you again through rebuttal. And so I want to take my time during this closing argument to talk to you about some of these instructions that you're going to receive from Judge Thompson. A lot of them are somewhat common sense, things like weighing the evidence, about discerning whether someone's telling the truth or whether you find something to be reliable or credible. And then the other instructions that you get relate directly to the laws and only the laws that apply to this case. So I want to go through that briefly here with you. I'm going to put the first one up here on the screen, and one of these instructions is called weighing the evidence. And the point of this instruction is that you can believe all, some, or none of everything you heard here during the course of the trial. It's up to you as jurors to determine what you believe, what you think fits with the other evidence in the case, and simply what makes sense to you based on your assessment of that testimony and evidence. You determine what's credible and what's reliable, and this is that everyday concept of trying to decide what is being told to me and whether that's true. Things like, did the witness seem to have an opportunity to see and know the things about which they testified? Really basic example, did the arriving officer, Officer Vega, who arrived on scene, try to talk to you about the autopsy? No, that's an exaggerated version of that. But at the same time, did the girls who were the eyewitnesses to the event that survived, did they try to talk to you about what their perceptions were based on the very extenuating circumstances of the trauma they experienced? We can't forget that Luann Dejet and Emma Wright were not just witnesses to their friend being shot and murdered in front of them. They were victims of an armed robbery themselves on a dark road in an unexpected event. So you have to consider what they heard, what they saw in that context. Additionally, you have to consider whether the witness had an accurate memory. Were they honest and straightforward in answering the attorney's questions? And that goes for both sides. Some of the questioning got a little bit contentious, and you can consider how those questions were asked, how they were responded to, and also the nature of the questions. Were they confusing? Do you believe the witness understood the questions being asked of them, and was the response responsive to that? Were they evasive in trying to answer those questions? I'm going to skip down here. Does the witness's testimony agree with the other testimony and other evidence in the case? We had the benefit of having this whole stream of data that includes that track with the GPS on the Hertz car, the cell phone tower data that tracks right along, and those license plate readers. That's the kind of thing that is consistent with the testimony that you heard from the witnesses in the car, Thomas Stein and Christopher Horn, about the path they took and what they did. I'm going to bring this up here. Has the witness been threatened or pressured to give testimony? Have they been offered a benefit? You can consider that. It's important that you can consider that and whether that person provided testimony willingly. Does the witness have an interest in the outcome of the proceedings? That's important as well, because the defendant made himself a witness in this case when he elected to testify. It's on the last page of this instruction. You can consider all of the things that you would consider about any other witness and their testimony and reliability and credibility the same way that you consider the defendant's testimony. One of the other things that is important we discussed during voir dire has to do with reasonable doubt. And in this whole book of instructions you're going to get, it's loaded with definitions. This means that, this is defined as something else. You're going to receive all of that. But what's really interesting is that the definition of reasonable doubt is actually a non-definition. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. What you're going to learn from these instructions and how you are to consider the evidence is that we can tell you what a reasonable doubt is not. If you're having to force yourself to imagine that this was not a robbery, you have to force yourself to believe this was just a couple of kids, they didn't know what they were out doing, that is not a reasonable doubt if you're having to force yourself to do that. If you believe Thomas Stein was trying to be a hero that night, but you're having to force yourself to come to that conclusion because just because he said it on the stand and you're having to say to yourself, well, he said it, but it doesn't really make sense or jibe with the rest of the evidence I heard, that doesn't form a basis for reasonable doubt. Because the concern is whether there's an abiding conviction of guilt. If you as jurors believe that this was a robbery from the start, you don't have to force yourself to imagine that it was something other than a robbery from the start. And you shouldn't be influenced by forcing yourself or imagining or speculating about what could have been, or maybe it was this way. If you believe this was a robbery from the start, it was a robbery from the start, and you don't have to force yourself to imagine alternate outcomes or scenarios. All of the instructions you're going to hear are going to include a reference to what's called principles. And this was discussed again in voir dire. This is that idea of in for a penny and in for a pound. We talked about this in voir dire under the concept of the house party. There's not a criminal activity going on, but these two individuals threw a house party, the person who holds the door and the person who invites everyone over and gets the beer, those people are equally involved in that because they both participated. And the actual instruction reads that if the defendant helped another person or persons commit or attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did. In for a penny, in for a pound. In Florida, we do not let defendants hide behind the actions of other co-defendants. If this individual was involved in a robbery, everyone involved in that robbery is equally responsible for that crime. Say it again, in for a penny and in for a pound. This is important in this case because what we know is that Thomas Stein was the driver the entire night. Thomas Stein armed himself and he armed Christopher Horn. The two guns they carried that night came from Thomas Stein himself. And by that was by Thomas Stein's own admission that he had given that gun that had been Darrell Ford's gun to Christopher Horn. That 1911 we see flashing around in that rap video just not even an hour before the robbery with the red laser light. That's that 1911 that Christopher Horn was handling. But Thomas Stein provided that. That wasn't brought to the event by Christopher Horn. Thomas Stein armed Christopher Horn. And he didn't arm him in anticipation of going car hopping. You heard what car hopping was, jiggling door handles to see what we can find inside. There's something missing from that concept, and it's the need to use force with a firearm. You can use your common sense about why a firearm was needed that night. Gun was needed that night because the plan from the jump was that this was a night of robbery. The plan was never just to stick to car hopping. You can consider the testimony that you heard from Thomas Stein. He was okay with car hopping. And then the plan backed down because he just didn't know what was going to go on. These other individuals got in the car. I don't know what we were doing. I just was driving. Interestingly, he drove directly to a second movie theater. Keep that in mind. They'd been at a movie theater and driven through the parking lot at Merchants Crossing Theater, the AMC in North Fort Myers, himself and Christopher Horn earlier that night. They wrangle, they decide what they're going to do. And where do they go? Directly to Cape Coral, directly to the Marquee Cinemas, and drove through that parking lot. You can review that GPS data, but you heard Destiny Robidoux talk about the timing of that. The vehicle didn't stop in the parking lot. There was no one jumping out and jiggling door handles to see if they could find someone left their car open and left some weed or some money in the car. They were stalking a target for their robbery. When Thomas Stein was asked on the stand, once you picked up the other people that you're saying you picked up in the church parking lot, what was the plan? Speechless. He had no answer because the answer is they were going to rob someone. He couldn't come up with something from the stand to tell you about what the plan was that night. That was.
See, this pisses me off, the over dramatic and all this. I understand this, whatever, it's drama. Bitch, your fucking main witness, he didn't even put him on the stand. The defense did. You gave a guy a sweetheart deal of 25 years, and you didn't even put him on. What about his testimony? His lies? He was not even credible. At least Thomas Stein was credible. You didn't have the fucking balls to put your key witness on the stand. I just hate this bullshit. There's a lot of speculation going on. And this is the part I hate. That they're allowed to speculate and make inferences that are not even fucking true.
Wasn't incriminating as it relates to this felony murder charge. This principal instruction is going to come up over and over and over again during the instructions because this concept of in for a penny, in for a pound applies to all of the criminal behavior. I'm focusing on this robbery because that's the main charge that we're here for, but you are going to hear it on every single charge that you're going to be instructed on. And you can consider that in your deliberations. Count 1 of our indictment charges first-degree felony murder. To convict the defendant for first-degree murder, and I'm going to emphasize this, I've highlighted it here, it is not necessary for the state to prove that the defendant had a premeditated design or intent to kill. They didn't have to go out that night and plan they were going to kill someone to take their property. The point of felony murder is that they planned to do a crime that is so inherently dangerous that any death that results from that crime is first-degree felony murder. That's the point of this law, and you went through that during jury selection. This is that arson example. Some crimes are so inherently dangerous that it's reasonable to expect that your actions will result in a death. Arming your friend to go out to commit a robbery is what the defendant did. That action is inherently dangerous. And that's why he's guilty of this felony murder at a minimum. That's the very least of the evidence that implies that the defendant is guilty. The elements that you see here are the elements that the state is required to prove. First, Kayla Rincon-Miller is dead. It's not at issue. That young woman was a 15-year-old girl. You saw the autopsy photos of her laying out after being deceased. You heard from the medical examiner, an autopsy was conducted. You saw a copy of the death certificate. That's in evidence if you'd like to look at that. She died due to a gunshot wound. She is deceased. Element number 1 is not at issue here. Element number 2 calls that while engaged in the attempt to commit a robbery, Thomas Stein, and I've circled it here, or Thomas Stein's accomplice caused the death of Kayla Christine Rincon-Miller. What that means, you can lift some of the burden of this case off of your shoulders, because for this charge, you are not required to know or decide or determine who pulled the trigger. The only question, which is very, very, very narrow, is whether these individuals were engaged in a robbery at the time Kayla died. A lot of this case could get blown up as being a much bigger, grander issue. But element number 2 makes clear that this is a very, very narrow issue where these individuals engaged in a robbery or an attempt to commit a robbery at the time Kayla Rincon-Miller was killed. It doesn't have to.
Okay, I think he's fucks. I think most of the jury, I think, will say there was probably a robbery being planned. So I think a lot of the jurors will now find him guilty on that point. If that's the case, and you were able to just go, well, he didn't kill her, but part of his group did. So if that's true, and we'll listen to what the defenses say, I think they're going to fight it very hard not to find him guilty. So I didn't know that going into this, but yeah, that's going to be a tough one.
To be Thomas who shot her, it doesn't matter. The question is, as a group, were they participating in an inherently dangerous criminal act, and as a result, Kayla Rincon-Miller was killed? The answer is definitively yes. But let's talk about what that robbery means. You get a whole instruction about what robbery is and what attempted robbery is. I want to talk about that, and I think it's easiest to work backwards. So at the end of the instruction, you get this principles again that I told you would see pretty much on repeat, okay? The principle theory applies to the robbery that we're talking about. If Thomas Stein did anything to incite, cause, encourage, assist, or advise, then he is a principal. And if he's a principal, again, then he is treated as if he had done all the things the other person or persons did. The attempt simply means they tried to do a robbery, but they failed. You heard there was a scuffle, a struggle. Kayla fought back against the person trying to rob her. Emma had a bag across her body. She was not giving that bag up. Luann DeJet had a bag under her arm. She didn't give that up. Just because they weren't successful at committing this horrific attempted crime, it doesn't mean that they get away with it. If they attempted to do it but failed, it's still an attempt to commit that robbery.
I hate this law. I hate all these laws that you are responsible for everyone else's actions as well. I hate that. That is so stupid. I hate it so much. So he potentially will get found guilty. I think probably will now get found guilty. And he didn't put like, oh, I don't know. That doesn't sit well with me at all. I hate this shit. Hate it. I do now believe he will be found guilty, by the way. I do, based on that. Well, I'm still holding hope that some jurors use common sense here as well. But I don't think it's going to be a not guilty. I think it's going to be hung or guilty, which based on the law. And I hate it, every second of it.
And then the elements about the robbery itself. And here, it's important to remember that principle, because where you're seeing Thomas Stein, it's Thomas Stein or one of the perpetrators together, if they're acting in concert with one another to effect this robbery, did take or try to take the purse from Kayla Rincon-Miller. That force, violence, assault, or putting in fear was used in the course of the taking. You can think about the rapid nature of how this happened. Once that car turned around, the lights flashed, the doors open, and in an instant, give us your shit, give me your shit. It was a robbery. Those girls, despite thinking at the moment this might be a prank, it's because it was terrifying. They were armed individuals with these girls on a dark street where there was no one else around. The fear that was used, that's the point of bringing a gun to a robbery. You want to scare the victims into giving the property that they're trying to take. And the point is that the girls did have items of value. They may not have had a ton of money with them. Their purses had value. They had items in their purses that had value. And the point is that they were trying to take something that didn't belong to them. And it wasn't just a joke. They weren't taking it temporarily to give it back. You can infer that from the testimony that you heard. And again, that rapid nature of how this took place. This robbery was the plan from the beginning. Thomas and Christopher Horn's plan, and also if you believe the testimony from Thomas Stein about picking up those other two individuals in the church parking lot, it was their plan as well. And we know that both because of how Thomas behaved in operating that vehicle. Think about what I talked to you about in opening statements. They're driving through that movie theater parking lot. It's a well-lit area. The bank, vehicles there at the ATM, well-lit area with cameras. What did they do? They identified what they thought was a soft target. 3 girls walking down the road alone. Stopped behind them to check it out. Turned around and came back to get a better view. Committed to the plan by making that U-turn and passing them again before turning around to blind them with their lights. That's not a couple of boys out trying to holler at some girls. Those are criminals looking to rob an easy target and scoping out the best way to do it. We also know this was the plan from the beginning because, again, they went armed. I'm not going to keep harping on that. It's like you don't bring a gun to a fist fight. You don't bring a gun to jiggle door handles to try and find small amounts of weed and pocket change in a center console of a vehicle. And again, what you heard from Emma Wright and Luann Dejet about what happened when those doors opened, it was immediate. Everyone was out. The boys were at them in moments demanding their belongings. This idea and this charge of felony murder means that you do not have to decide who pulled the trigger. But if it was one of the people who's working in concert with Thomas Stein, then he's guilty of felony murder. They don't have to have known each other before they did this. If the plan was to do a robbery together, they're each responsible for the action that resulted, which was Kayla Rincon-Miller's death. This is only the case of State versus Thomas Stein. We're not here in case the State versus Christopher Horn or the State versus any of the other perpetrators. Your job here is only in regard to Thomas Stein. Again, Thomas Stein supplied the car, he supplied the weapons, he has supplied the escape. And what did he do after the murder? He burned his clothes, he got rid of the gun. That's not the activity of someone who merely wanted to intervene to help a girl who was being robbed. That's what he asked you to believe when he testified on Friday. He got out of the car bewildered. What's going on? The shooting happened, and then he said, oh no, that's too much for me. Let's get back in the car and go home. Those two stories don't line up. He wants you to believe he was going to be the hero that night and rescue Kayla from JD, who was going to jump out and was struggling with her, and they were fighting. So I'm just going to get between them. Weigh that evidence to decide whether you think that's credible based on the circumstances, based on him driving the car that stalked those girls in order to do that robbery. It's easy, again, to get distracted because this is a highly emotional case. There's a lot of moving parts, there's a lot of pieces, but it's that very limited issue. This was a robbery, and Kayla Rincon-Miller died as a result. And then here in element number 3, in first-degree felony murder, Thomas Stein was the person who actually killed Kayla Rincon-Miller, or she was killed by a person other than Thomas Stein, but both the person who killed her and Thomas Stein were principals in the commission of the attempted robbery. That's that element 3. The instructions about murder can be confusing and they can be overwhelming. You're going to receive other ones that are also very verbose about excusable homicide, inexcusable homicide. What this boils down to is what's contained in the first part of this felony murder instruction. You don't have to be distracted by those. You have to listen because it's important. The Florida law requires that you listen to those instructions and consider them. But when you try and process what you've heard, it boils down to this. Why we're here today. The primary question is, was Thomas Stein involved in the robbery? When the answer is yes, the verdict is guilty as charged on count 1. The verdict form, there's an instruction before you get the verdict form, and it talks about if you return a verdict of guilty, it should be for the highest offense on the verdict form that's been proven beyond a reasonable doubt. You're going to receive information on some lesser included offenses. I'm going to talk about this briefly in a moment, but I bring this up because first degree felony murder, letter A on the verdict form that I'm going to show you, is the highest offense charged for count 1. It's just in case it would be confusing. This is a copy of the verdict form. I placed it on the viewer. The special additional instructions that you're going to get are related to count 1. Those involve whether Thomas Stein actually possessed the firearm. Did he have a gun in his hand? Was he armed at the time? Those are all special instructions that the judge has to give you. Those questions are answered on special findings forms after the verdict form. And it can be kind of confusing, but the judge is going to give you the full instructions. So if you find the defendant guilty of first degree felony murder, you have to answer each of these questions. I want to point this out because what you answer on this special findings form has no impact on whether this is felony murder. The robbery gone wrong relating in the death is one inquiry itself. And if you find guilty of that, then you have to answer these questions. But if you find that the defendant didn't have a gun at the time, it doesn't mean he's not guilty of the felony murder. And I just want to make sure that everyone's clear on that because these are voluminous and somewhat confusing instructions. In addition to this main charge in count 1, you will receive instruction on lesser included offenses. And when you hear those instructions, you might think to yourself, oh, that kind of sounds like this. Or maybe it's this instead. And I want to point out that second degree murder, it's a killing. Someone's dead, in this case, Kayla Rincon-Miller. But what's missing from the second degree murder instruction is that it was committed in the course of this inherently dangerous crime. The court is going to instruct you on this, but it doesn't apply here because where we're at for the highest offense charged is that this was a robbery. And in the course of the robbery, Thomas Steiner, one of the co-actors, also committed the murder. That's what makes it felony murder. And so second degree murder is something you're going to receive an instruction on, but we're missing that component of it being committed in the course of this dangerous crime. Same thing goes for manslaughter. You'll receive an instruction on this. And again, there's someone who's been killed, but again, it's missing that component of it being in the course of this very dangerous crime. Yeah, just a moment. Slaughter that I want to emphasize when you're thinking about second degree murder and manslaughter, that this was a robbery from the start. Thomas had secured the vehicle to drive, which mind you was his mom's rental vehicle. as a 16-year-old. He obtained the guns, which he says are normally stored in his mom's gun safe. He had to get those out, have access to them. He didn't just keep it at home like the marijuana he says he's allowed to smoke in his yard in a controlled environment. He took that rental car, he put armed people inside with his guns, and he went to the scene. Under no circumstance is it believable that Thomas Stein is the only one in that vehicle that didn't know this was going to be a robbery. And that's what you'd have to believe to think that this event happened the way that Thomas Stein told you that it happened. He asked you to believe that these people got in the car. They're a lot more thug than him. He really didn't know what to do. They were Christopher Horn's friends. Is that plausible? Does that make sense?
Does that make sense? Yeah. She didn't put any of these witnesses on. So she's speculated about all this robbery and but she didn't herself put any of these witnesses on. It's like, if you have all this, then put them on the stand. You haven't. So there's no evidence that they were going out for a robbery. So you're pushing a narrative that has not come in. That they deliberately went out and that's all they were going to do was to cause a robbery. So I just don't like this. I just don't like it. You take an oath as an attorney to tell the truth, and the fact that they can just do this bothers me.
Watch the video that they made 45 minutes before Kayla's murder, what they were going to get up to. Is it plausible that Thomas Stein is the only one? He's the innocent party here. He didn't know what was going to happen. Going back to those considerations about those special findings forms, I want to talk to you about how the principal theory that we've gone over and over doesn't apply to those. The special findings about whether Thomas Stein possessed a firearm, whether he discharged a firearm, those are specific to Thomas Stein. So I don't want you to be confused. And again, your determination of that doesn't have any impact on the finding of felony murder. But it's important because you heard some evidence that you can consider about whether it was Thomas Stein who fired that shot. You heard from the medical examiner, and I'm placing Exhibit 7D up on the screen. You heard from the medical examiner that this image was taken of the gunshot wound to Kayla Rincon-Miller's chest. She pointed out to you this area of abrasion here in the photograph. And she told you that as far as her experience in doing hundreds of autopsies, that's not from a medical intervention that she's familiar with. How did that get there? And that question was set out to be answered by the investigators in this case. And they did a lot of legwork to try and figure that out. There was a video that you saw of Thomas Stein holding a Glock 27 weapon. That's Exhibit 23. Sorry, I give you the right number. Exhibit 23. A screenshot from that was taken of Thomas Stein holding that Glock 27. And you heard from the detectives that they were able to slow that video down and identify a serial number on the gun. And they worked to identify that serial number and learned that Thomas Stein's mother had purchased a Glock 27. You also heard that during the execution of the search warrant, that Glock 27 was not at his house. The detectives asked Amy Schober to try and run with this, to try and figure out if that Glock 27 could potentially be involved. She didn't offer you an opinion. This is up for you to determine how this evidence fits within the case. But she told you that she checked out or viewed a gun at a local gun dealer. This is State's Exhibit 26. It's really hard to see a little bit there, but these images can go back with you into the jury room. And she noted something about that firearm. And it was these unique markings, at least in this gun, this Glock 27, at both the back of the gun as well as where the muzzle is. So that's used to help when they're going to rack the slide of the gun. And she set out to at least present this evidence so that the jurors could see it here today.
Hang on, don't lie. She tested that gun because you asked them to. She tested no other gun because you never asked them to. She has no opinion on anything. She's like, oh, some of it might fit in with the shooting. And the defense asked, well, did you test any other guns? Did you test? No, the state never asked me to. So let's not fucking lie here, bitch.
And she made this overlay that showed the front portion of that muzzle with those markings and whether they coincided with those marks on Kayla Rincon-Miller's chest. When you consider this evidence, along with the testimony of Dr. Noelia Hernandez, that this weapon was fired so close to Kayla Rincon-Miller, she said 2 to 3 centimeters. These markings are something for you to consider about where they came from.
Well, they can't consider anything because you didn't ask them to test anything. You just said, just do this and say this, and the jury, there you go. How about testing all the other guns? How about testing things that's similar to that gun? No, you never asked her to. So you've literally just said to the jury, this is the only gun it can be because of this reason. We haven't tested any other gun because we didn't need to. That's bullshit. That's bullshit when it comes to a murder trial like this. This is disingenuous. What I don't know how the fuck you say that word, disingenuous or whatever it is. I hate this shit.
This case involves a tremendous amount of circumstantial evidence. It doesn't mean that it's not good evidence, because these pieces line up together for you all to make your decision. The remaining 3 counts in the instructions that you're going to get all are the same. It's just one separate for each of the victims, and that's the robbery. Or, excuse me, I misspoke. This is the attempted robbery. I have included count 2, but count 3, 4.
You've misspoken a lot in your closing, so don't worry about it.
And 5 are all the same. It's just that the victim is different. One for Kayla Rincon-Miller, one for Emma Wright, and one for Luann Dejet. And we've gone through what a robbery is when we're talking about felony murder, because that's the underlying offense that brought us here today on the felony murder charge. The principal instruction applies to all of these the same way it applies as we've already discussed. All of the evidence you've heard has to be considered by you in determining what occurred on that day. But you don't have to determine everything that occurred on that day. You have to determine whether Thomas Stein was a participant in the robbery, an attempted robbery, on March 17th of 2024. It's a very narrow question when you boil down all the evidence and what the law is that applies. The defendant's actions after the murder are really pertinent to your understanding of what his role was. I want to talk about that because both he and Christopher Horn burned their clothes. Both he and Christopher Horn got rid of their guns. Thomas Stein asked you to believe that he merely wanted to intervene between Kayla and the shooter. Why would he feel the need to burn his clothes? Does that make sense to you? Or does it tell you something?
It does make sense to me because, as he explained on the stand, one of the guys said everyone has to burn their clothes. He didn't want to, but it was like, you have to. You got no option. Burn your fucking clothes. He was made to burn his clothes. So stick that in your pipe and fucking smoke it, bitch. I don't mean to call her a bitch. She's not a bitch. Yeah, she is a bitch, actually.
Else about what his role was that night. Thomas Stein told you a lot about that night. On Friday, he told all of us he knew who the shooter was. JD, some other guy, Trey, also got in the car. You can consider how his testimony carefully zigged and zagged within the testimony of the girls that you heard from at the beginning of the trial, as well as all the other evidence that had already been admitted by the time he testified. You can consider that. He sat before you and tried to paint himself as an attempted hero that night. He tried to paint himself as the victim, as the patsy for this entire event. He told you he was willing to stop a fight, but once that shot was fired, that was it, and he took off running. This would-be hero burned clothes. His mom exchanged the rental car. Exchanged, not turned in. She turned in that car and got in a different one the same day, the day after the murder, the morning after the murder. And then he sat here on Friday and told us all the name of the shooter, or at least the initials. He didn't help Kayla that night. He didn't try. He was not on the heroes team that night. He is not the victim here today. There are 3 victims in this case: Luann DeJet, Emma Wright, and Kayla Rincon-Miller. The state asks that you find the defendant guilty as charged of felony murder, of attempted robbery of Kayla Rincon-Miller, of attempted robbery of Emma Wright, and of attempted robbery of Luann DeJet.
Sure.
Morning, everyone. And in the state's theory of the case, that equals felony murder. But there's a problem with that. So if there wasn't, why would I be here? Why would I be standing before you right now? The problem is that the law says the state must prove that Thomas Stein intended for this to occur.
Objection, the statement of the law.
Ooh.
There are 4 main lies told by Christopher Horn. 1, who the shooter was. The shooter was this guy, Jaden. This is just a made-up name I picked out of a hat. The shooter is Thomas Stein, right? In order to save his bacon, that's what he's saying. Another lie. What'd I do with a gun? I emptied it over here. No, I put it in the canal. Even in jail, he's telling everyone, no, I got rid of it in the canal. The police searched that canal. There's nothing there. What'd I do with my phone? Oh, I chucked it over the side railing of the bridge. It's sitting in the Caloosahatchee River. Well, guess what? The police looked for that gun, for that phone, and it's not there. And the biggest lie he's told is that there's only 2 people involved that night, right? You know, and the state keeps making the situation even weirder. It's just a couple of kids out, committing robberies. Or on the other hand, there might have been 2 other people involved if you look at the evidence. Of the 4 people that got out of the car that night, only 3 had the intent to commit a robbery. Two people were arrested for that crime, but there's still 2 more people out there. And I'm guessing Miss Miller at the end of this, right, she gets to give a rebuttal, is going to say something along the lines of, it doesn't matter if you believe there's 2 or 4, as long as Thomas Stein and Christopher Horn are involved. It's felony murder. And we're going to talk about why that matters. Because at the end of the day, There's only one person on trial today. That's Thomas Stein. You know, at the start of this case, the state makes all these promises to you in their opening statement, right? Do you remember? I asked you to write them down if you could, because they have to keep those promises to you. And they said,
Objection. Statement of law.
Overruled.
they said that they knew exactly who the shooter was and they could be identified. The state has served you 13 different witnesses. 13. Right? Let's pretend it's like we're sitting down for this fancy dinner. 13 different witnesses. 13 dish main course. Some, like Luann Dejai, very straightforward. Right? Her testimony has been unchanging. She is a victim in this case. Absolutely, 100% agree with you. It's important to remember that sympathy is human, right? To have sympathy for someone, it's human. The empathy that we feel is normal, but we can't let it dictate what the verdict in this case is going to be. You guys in particular were selected, right, during that jury selection process for a very particular reason. Common sense. We thought you had the best common sense. We thought you could read people the best, right? Because we've established this is not a truth-telling box. But you're only going to have, from the time it takes to walk from those doors to this stand, to size them up. That's all you got. Lastly, you were chosen because you have the intestinal fortitude, right? To stick to your guns, to deliberate this out. That if there's something wrong with this dish the state is serving you, you're going to send it back to the kitchen. The verdict in this case must be unanimous. That means you all must agree. Everyone here. Did the state prove the burden beyond and to the exclusion of all reasonable doubt, right? And here's the question. That Thomas Stein knew about the plan to rob Kayla, to rob Luann, to rob Emma, that he intended for it to take place and took part in the robbery. It's quite the opposite. And again, reasonable doubt, right? We talked about reasonable doubt during the voir dire. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. But on the other hand, if, after carefully considering, comparing and weighing all the evidence, there is not an abiding conviction of guilt, or if they having a conviction, it is one which is not stable, but one which wavers and vacillates. The charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. You know, the state's talked about this principles theory, and I'd like to go over that jury instruction also. There's two things the state has to prove to you, right? If the defendant helped another person or persons commit or attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if the state proved beyond a reasonable doubt. Here we go. 1, the defendant intended the crime to occur. You stop. Did the state prove beyond a reasonable doubt, right? Did they give you any evidence that he intended for this to occur? Testimony of one man, Christopher Horn. And the defendant did some act or said something that was intended to and that did incite, cause, encourage, assist, or advise the other person or persons to actually commit or attempt to commit the crime. But there's a bottom portion of that instruction, and it reads like this. Mere knowledge that the underlying attempted robberies are being committed and mere presence at the scene is not sufficient to establish that Thomas Stein is a principal to felony murder.
Well, fuck me sideways, please. That is fucking wrong. That the prosecutor didn't mention any of this shit. Again, how disingenuous do you have to be as a prosecutor to state, because the way she stated it, I was like, oh, this guy's fucked then. But this is just, we'll go back a little bit, listen to this, because this is totally different to what she fucking said.
But there's a bottom portion of that instruction, and it reads like this. Mere knowledge that the underlying attempted robberies are being committed and mere presence at the scene is not sufficient to establish that Thomas Stein is a principal to felony murder. We talked about this a bit in voir dire. When Mr. O'Brien, who's sitting over here, he's from, I think it was Boston. He's talking about the star athlete that had his whole life in front of him. And he was with those kids that went in and held up the store clerk. And now he's serving life. In Florida, it's a bit different. The state must show that there was intent for that crime to have occurred, right? You can't just sit there. It's got to be more than that. There's going to be a whole litany of charges that are read because the state says, well, if we can't get them on the felony murder count, maybe they'll come to an agreement as to second-degree murder. No, not going to agree to that. We'll go with manslaughter.
Oh.
They can ask for lessers in this case, and they have. But after each lesser, you're going to have the same instruction on principles, right? You're going to have the same instruction as to independent act. If you find the crime of attempted robbery was committed, an issue in this case is whether the crime of attempted robbery was an independent act of a person other than Thomas Stein. An independent act occurs when a person other than Thomas Stein commits or attempts to commit a crime which Thomas Stein did not intend to occur, in which Thomas Stein did not participate, and which was outside of and not a reasonably foreseeable consequence of the common design or unlawful act as contemplated by Thomas Stein. If you find the underlying crime of attempted robbery was an independent act of another person, then you should find Thomas Stein not guilty of the crime of attempted robbery. And here's the thing. If you find him not guilty of the crime of attempted robbery, you must find him not guilty of felony murder. It's what we call an interlocking charge. Okay. So let's talk about the testimony that we received. And I'm gonna break them down in chunks with the exception of one. Detective Lander, I'm going to kind of save the last because he was the lead detective kind of putting everything together. So in terms of law enforcement, our investigation witnesses, we have Officer Vega. He's first on scene. He did his best to render aid to Kayla. But what do we know from his testimony? There are 4 or 5 subjects. He's fresh on the scene. We know there's 4 or 5 subjects. Gray SUV, going that way. One was a white male, 3 black males. Sergeant, gun. He failed to collect DNA from the hospital when he was on scene. And that's okay. We're doing okay. But why else call him? But for the simple fact to recount the very emotional moment Kayla's parents found out that she had passed. As heartbreaking as this account was, once again, we can't let sympathy guide us on our verdict. Next, we heard from Lansky, who is a retired CSI specialist. Of all the things that was found on the scene, of all the things that she didn't swap, thank God there was one thing she did, and that was the purse strap that was being held by Kayla Rincon-Miller, the purse strap that was being struggled over by her and her assailant. We know that Christopher Horn was excluded as a contributor. We know that there was a partial DNA profile developed, male contributor. But we also know that that male contributor is not Thomas Stein. So we know that there's at least 3 people, right? If you believe the witness accounts, there's definitely 4. We heard from Officer Alan Precy. He got the license plate reader, kind of gave it the big break on the case, tracking the SUV. We heard from Destiny Robidoux, which is so close to Robidoux. Destiny Robidoux says that she was able to plot the map points, right, of the GPS from Hertz. We were able to plot the cell phone tower records from both Thomas Stein and Christopher Horn and his mom and Jaden Fernandez. We heard from Amy Schober, who is an employee at the Cape Coral Police Department. She's the CSI specialist, right? And I kind of fit this into the category of junk science. Am I crazy? Or did she really say she photoshopped some evidence to see if it matched? It was made to fit. And that's the overarching theme of this case. Did she test any other weapon, including the 1911 that we know was on scene, right? Well, no. I just tested what Detective Melissa Landry told me to test. She considers herself a forensic scientist. That's not how scientists behave. We heard from Detective Scarlato. He introduces this video with Christopher Horn, right? He's waving around this 1911 with the laser and the pistol grip. Terrible music, right? And the state is trying to make this connection. Oh, but listen to the lyrics. The lyrics themselves give you the plot. Doesn't. I heard this phrase, demon seed. What's that? What does that even mean? Detective Scarlato, he corrects Emma Wright's testimony, who said, I know that the shooter was not the driver. And we know the driver was this guy. We know that there's more than 2 people, according to his testimony. And that the shooter, in fact, was in all black and a red hoodie. We heard from Detective Noelle Hernandez that we don't know what the caliber of the murder weapon was. Glock 27 is a .40 caliber weapon. 1911 is a .45. We don't know what it is. It was a through and through, right? So that means at least the majority of the bullet, we would think, passed through her remains. But we don't know if there were fragments that were still there. She didn't know if fragments were still there. She couldn't tell us. She wasn't the ME who did the original examination. In terms of non-law enforcement witnesses, we have Jessica Stein. single mom of 8. She has 4 kids living with her at home. We put this picture of her home before you to consider. She tells us how she was threatened by the Horn family. Listen, it's very clear Thomas is going to be arrested, but I need you to keep my son's name out of his mouth. They even offered to pay for his lawyer. Not me. We heard that Christopher Horn Sr., Chris's dad, who's got some knowledge of criminality, says this is how you dispose of evidence. We heard from Jaden Fernandez, and now we're getting closer to the event. He's known Thomas for 2 years. They met at school. Just some neighborhood kids doing neighborhood things. And I don't know if you saw Thomas watch his friend testify against him, but he couldn't help but feel sad. But for this event, I could be going off to college. I could be playing ball.
Sustained.
You know, but he's got this strange category of friends, right? We have Jaden Fernandez, who just spent the day with him and his family.
That winds me up because the state, I know the defense didn't object, but the state have said a lot of shady shit in their closings. And now they object to that. I mean, maybe the defense attorney should have objected, but I'm sure he doesn't object because he doesn't want to come across like a dick.
Going to the beach. Very wholesome. You know, very teenage boy. Going up to girls, chatting them up. We asked Jaden, did Thomas have any ops? And for us older folks, ops means opponents or people that you have beef with. His face kind of screwed up. Thomas didn't have beef with anyone. And Thomas definitely never said, I want to rob a Chico. Or I want to catch a body. And these are 2 statements that Christopher Horn said. You know, Detective Les Salandra, he told us how the car stopped. And we know from the GPS records from Ms. Rabadou that was for 7 minutes. The car stopped in a church parking lot, like they were meeting someone that's over there. The car parks next to him. We know this because the pastor was kind of seeing what was going on over there, right? We didn't hear from the pastor, though.
Sustained.
I asked to strike the comment by counsel.
I'm sorry?
I'd ask that the jurors disregard the remark by counsel.
I sustain the objection. Move on.
Detective Les Salandra confirms there were more than 2 people, right, that he's investigating. He confirms that the DNA found in the purse strap excludes Thomas Stein. He confirms that the investigation is still open. He says that based upon his investigation, there were 4 people, 2 guns. Not even the state's main investigator believes Christopher Horn Jr. Let's talk about the victims in this case. The victims are consistent with one thing. They said that there's 4 shooters. One, the most obvious, was a white male, right? We know this because he slowed down to 5 miles an hour as he passed him. And he's checking him out, his arms in the window. They could see that he has blonde hair, and he's looking at them so hard, and they're looking at him so good, they can tell he's got blue eyes. Another male that they saw was a black male in a red shirt, loud writing across the front. He's in shorts. He's got a mask on. A third male, heavy set, black male, red hoodie, blue pants, who we can only assume is Christopher Horn Jr., wearing a mask. Finally, we have a black male with short twists, the t-shirt covering his face, and all black. We can only assume that this person is JD. But when I asked her about the 4 people at the scene, she makes this comment to us. She thought, I was talking to Emma, and we thought to ourselves, am I crazy? Am I crazy? William, what do you mean by questioning your own sanity? Why would you do that? Maybe we didn't see the things we thought we saw. We're talking about perception. Who told you there's only 2 people? State did. Because that fits that square peg into that hole. But she said, I need to tell the testimony that I saw. I'm going to tell the truth. And she did. Let's talk about Val. Am I right? Still 4 people, right? Still the same descriptions. Her testimony last week was inconsistent with every single time she had given testimony previously. Every single time that she talked to the officer on the scene, she talked to detectives later on. She talked to me in a deposition a year and a half later. She was 100% certain, her words, not mine. The driver was not the shooter. The driver was not the shooter. That Thomas ran in front of her to the 2 people, to Kayla and the person, her assailant, that were struggling. Who we think at this point is JD. And a shot rang out. Why would she change her testimony? She said she didn't talk to anyone about her testimony prior to taking the stand. Right? And then I sat down. Then Miss Wolf gets up. Oh, Miss Wright, come on, you remember. You and I had that conversation, right? We had that conversation. And upon your reflection, after these years, upon your reflection, the shooter is now the driver. Why would she claim that? When she walked through those doors, and she stood here, held up her hand, swore to tell the truth. She looked over at this table. She recognized a person that was there. She lost her friend, and she wants justice, and I don't blame her for that. Someone should pay. But here's the thing. Justice doesn't cut corners, and the right people should pay for this. And even though we don't have a burden to do so, the defense put on a case. And we made mention in the opening statement of the state's star witness, right? This co-defendant that was there, this testifying co-defendant, this flipping co-defendant, this rat, whatever you want to call him, right? He was bought at a high price. They bought this testimony at a high price. They cut him a deal of a lifetime. At his age, he will be out still in his 30s. If, big if, he's not caught lying on the stand. The state star witness wasn't called by the state in their case in chief. Why? He's got too many lies. He can't keep it all straight. His account's all over the place. Once again, there aren't 4 people getting out of the car. There's just 2. There's just 2. Jaden's the shooter. No, Thomas is the shooter. Where's my gun? Where's my phone? Sends police onto this wild goose chase. He gives one proffer, right, to the state after his arrest. They're like, you're lying. Try again. He does. He does give him a second proffer. But now it's made to fit. There's still only 2. Gets to keep his deal, protect Trey and JD. But if Sarah, right, because that's how they know each other, you're Chris and you know me as Sarah, right? If Sarah catches him in a lie, the deal is done. It's gone. He's got life. No takebacks. So worst case scenario, this guy can't hold it together on the stand and we catch him in a lie, he goes away for life. But it gives us a chance to take a bite at Thomas Stein. It's a gamble by the state. But I put him on the stand. Because I could have just sat down and said nothing. You would have heard from neither of the defendants. Because in Florida, life means life. That's what Christopher Horn is looking at. He goes into a box, and after he's dead, he's carried out of the box. Do you remember his testimony, how random it was? Yeah, we saw a guy. We saw a dude over by the ATM. You were watching the ATM? Yeah. It was a guy in a yellow Mustang. I don't know what you're talking about. Well, how'd you see the ATM? I thought you were watching it. He's all over the place. Detective Les Landra tells him this. During one of his proffers, it's like, these new cars, these newfangled cars, they are so highly technologically equipped, I can tell when the doors are opened. And that's when Christopher Horn says, well, you see, when I was running back towards the car, I was so confused as to where I was sitting, I opened the back door first, closed it, and then opened the front door and got in. That's not a thing. Law enforcement are allowed to lie to people when they're talking to them about their statements. But this kid took it hook, line, and sinker. We talked about that timeline, right? He is arrested. His mom and his dad and his aunt are arrested for witness tampering. He gives a proffer. He gives a second proffer. The charges against his family are dropped. And now he's here testifying before you folks. You refer to Thomas Stein as sweet. I'm like, can you tell me what that means? He's like, you know what it means. Did he send you candy? No. Mail you a Christmas card? No. That means Thomas Stein is sweet, which is meaning Thomas Stein will do what I tell him to do. I can go to his house, smoke his cartridges, smoke his weed. He can give me a ride. drive me around. He'll do what I want him to do. Within reason, right? Let's go try doors. Let's go see if some doors are open, some cars. We'll see if we can steal some change, see if we can find something of value. That's the plan. Why do we need Christopher Horn? Why does the state need Christopher Horn to testify? Because there has to be one iota of a plan that was formulated between the two co-defendants and the other two boys that later got in the car. They have to answer, did Thomas know a robbery was about to go down? They have to answer that question. And the defense having no burden put it in front of you. So next we heard from Thomas Stein. And I'll have to admit, right? He's on trial for he's in the trial of his lifetime right now. He's got everything to lose in this case. But still, even with that grain of salt, he's more credible than Christopher Horn. His story makes more sense based upon the forensic evidence. I exposed Thomas to the cross-examination of Miss Wolf, right? Knowing she would get to question him. Because that in this case, in particular, you have to hear it from the horse's mouth. And the advice was, you have to be truthful about everything. The ugly truth, yeah, he sells weed through telegraph. He even charges his friends, right? Because he buys the weed, he sells it for the same price, right? And he gets to keep a piece for himself. He didn't have to, but he still had to testify how he got rid of the gun. Because you, as the jury, would want to know why and how it happened. This is based upon the advice of Horn Sr. He admits to hanging out with Christopher Horn Jr. He advises that the plan was to try door handles, so they start driving around. What do kids do on a Friday night or on a Sunday night at the start of spring break? Everything's closed. What are you going to do? You drive around. You just drive around. There's a gun in the car because Christopher Horn likes to pretend they're hard. But the tenor, right? The atmosphere in that car changes when these two guys got in at that church at North Fort Myers. They're just driving around. You heard Thomas say it felt awkward. Like I didn't really belong there. Like these three guys knew each other, but not me. So let's look at this. What indicia, what facts indicate Stein knew the plan to rob these girls? Because that's the ultimate question that we have to answer. If he knew about the plan, then he's involved in the robbery. He's involved in the robbery. He's guilty of felony murder. But if he doesn't know about the plan to rob, and he's not involved in the attempted robbery, then he's not guilty of felony murder. So Tom and these three guys are driving down the street, and they see three pretty girls walking. And they're going to do what other teenage boys do. They slow down. They check them out. Thomas, in his gullibility and his stupidity, right? This is the plan to rob them. In his stupidity, he's just looking at them, right? Staring at them. What's up, ladies? They're giggling at him. He's not wearing a mask. These other boys are in the shadows. He's got a cell phone on him, right? Obviously, if you're going to go and commit crimes, you should have your cell phone on you. He goes live on Instagram that night. What's up, Kalina? What's good, JJ? He hears JD say, hey, I think I know one of them. Turn around. So he turns around. He flashes his lights at him. Hey, over here. I want to talk to you. Stops the car in front of him. And the doors burst open. He opens his door too. Like, what's going on? People are pulling down ski masks, running up with guns. And he's standing there. What's happening right now? He sees the struggle between Kayla and her assailant, JD. He's not claiming to be a hero. But he just wants to separate them because there's a struggle going on. Gunshot rings off. This is consistent with the true testimony of Emma Wright, who testified that she saw Thomas run from the driver's side in front of her, in front of the vehicle, to Kayla and her assailant. This is my last chance that I have to have a word with you. The state gets to get up here and try to rebut everything that I'm telling you now. But I need you to keep this in mind. Is there a reasonable doubt that Thomas Stein in this case didn't know that a robbery was going down? Based upon what we absolutely know to be true. That he slowed down, showed his face, not wearing a mask, had his phone with him, stood at the door, tried to intercede. Is this the case where Thomas Stein was actually involved in the planning of this robbery, which resulted in a murder? Or is this like Mr. O'Brien's case, where star athlete was just the wrong place with the wrong people? The judge will tell you that mere presence is not enough. Once again, Ms. Miller gets a chance to get up here, and she may say it doesn't matter, it's 2 or 4. But it does matter. Because he was definitely there, and he was definitely driving. There was definitely a robbery. The question is, did he know? And at this point, we have conflicts in the evidence between Christopher Horn's testimony, which is highly questionable. Even taking Thomas's testimony out of it, just look at the facts. Just look at the facts. Once again, justice demands that you find a just verdict in this case that's held in place by the evidence and the law that supports it. The right people have to answer for this tragedy. Thank you.
Is everybody in the jury doing okay? Okay. Let's move.
Emma and the gentlemen of the jury, Kayla, Emma, and Luann were the victims on March 17th, 2024. Don't be fooled by Thomas Stein's testimony. Don't be fooled by the lies he told you. He was not a victim. He was going out by his own admission to commit crimes that night. He told you he and Christopher Horn Jr. were going out to go car hopping. They were going to break into cars and steal whatever valuables they could find. They were not going to choir practice at church. They were not going to see the movies like our victims were. They were going to commit crimes. And at some point, their decision to just break into cars changed into robbing someone, changed into putting firearms in people's faces to get more.
Motherfucker, going around and trying cars does not mean that they were going out to set to rob these fucking 3 girls. And yes, everyone knows they're the victims. And no, he's never claimed to be the victim. He's never claimed to be a hero. So shut the fuck up with this narrative. Fuck. How can you make a leap from checking car doors to then going, well, he definitely knew that they were going to rob these 3 girls? Fucking infuriating.
And to get whatever they could get. Because it's more likely that a person has valuables on them than in their car. And you as jurors don't have to decide when that plan was formed. It could have been formed early in the night. It could have been formed when those calls were made between Christopher Horn and Thomas Stein and arranged for... It could have been made when they arranged to be picked up. When Christopher Horn sent that message of his address, they could have already had the plan to commit robberies. You don't have to decide that. Maybe the plan for Thomas Stein to engage in a robbery was when those doors opened. But what we know is that he participated in that attempted robbery of those girls.
We don't know any of that shit.
He may not have decided to rob 3 girls that night, but when he stopped his car and shined his lights on them and got and hopped out of that car as fast as he could, all while yelling, "Give us your shit," he was attempting to rob them. He played a role. He was not going there to hit on the girls. He didn't roll by them and roll down the windows while they all leaned out and said, hey girls, what's up? Can we get your number? No, he rolled slowly past them, drove by, drove around, and drove back to them where he quickly pulled his car at them, shined his lights, and they all hopped out of the car. And when I say they...
Right, if he's going 5 miles per hour, how could he quickly pull to the side? He literally is going to fucking standstill anyway. Let's not fucking over-exaggerate here. Look at the face she's pulling as well. I know I'm stopping all the time. I don't care. This is pissing me off right now. This is a DA in Florida allowing herself to fucking put this bullshit out there. Again, this woman took an oath of office. And in my opinion, she's just trying to pin something. There's two alleged... Well, there's one alleged killer out there. Her office is not... Don't know who they are. There's 2 people out there on the run right now about this case. I just can't. It's very hard for me to listen to this shit. I hate it.
It could have been 2. It could have been 4. It depends on...
No, there's no dependent. It was 4 people because the officer saw them, the victim saw them, the defendant stated it was 4. The only person that said it was 2 was your witness. Well, not your witness, but the key guy that you gave a deal to. That's the only person that said there was 2 people involved. And you didn't have the fucking balls to put him on the fucking stand. So there's no contradiction. There's fucking 4 people there. So don't bullshit me with that fucking shit.
On whose testimony you believe.
Not the guy that you gave a fucking deal with.
The victims say there were 4.
Yes.
And the state never told them to say otherwise. What do you know about the number of people involved in this case? What you know is that Detective La Salandra turned over every stone to try to put anybody and everybody on scene that night. He did tower dumps, and if you recall, the only people whose numbers hit all 3 of those towers were the 2 defendants charged for felony murder.
So doesn't that though, right, just to stop her there, she's pissed me off, does that not then go to the fact that the other 2 people were probably out there planning to go and rob some people, but the 2 people that had the phones were probably not planning on robbing anybody? So Thomas Stein and Chris Horn went out there to play with doors to go and get some weed. So they had phones on them. If they were going out to rob people, common sense says they would have left their phones at home, like the other two people did. So that goes against everything you're trying to say. In my opinion, the fact that they had their phones on them means they didn't go out planning to get to rob anybody. So that's fucking dumb.
And if you recall, there were only them and one other person who hit the church tower and the crime scene tower. And the third person was an Uber Eats delivery driver who had nothing to do with this crime. But what you remember, Detective Lander told you, if we could put anybody else at that scene, if any other information came forward, he would investigate it. And if he could prove that they also assisted in a robbery, they also could be indicted for first-degree felony murder. Ladies and gentlemen, you don't have to decide. You don't have to decide. Remember what we talked about in voir dire. The state has elements to prove. And my co-counsel went over the 3 elements to prove first-degree felony murder. We don't have to prove whether there were 2 or 4. In fact, if you had to go back there and decide how many people were involved with this robbery, you might have a reasonable doubt because there's conflicting testimony about how many people were involved. But there's not conflicting testimony that Thomas Stein was a participant in that robbery. And I'd like you to remember that Christopher Horn was never called by the state. And why is that significant? Because he's not a star witness. He had no evidence that the state needed to prove the charges against Thomas Stein. We didn't call him. You heard from all the state's witnesses, and then the state said, we rest, and we sat down. And the defense elected to call him. And as far as witness testimony, you can believe any, all of, some of, or none of the witnesses' testimony. You get to decide what you believe Christopher Horn was telling you, whether it was true or not. You get to decide how much of Thomas Stein's testimony to believe. And I would suggest to you that they're both lying. They're both giving information that's not supported by the evidence in this case. Defense talked about principle.
So if your guy that you gave it to was lying, are you going to revoke it? Because the only reason he was allowed to have a deal was if he agreed to speak the truth. So you're going to revoke it then if he was lying?
That the defendant intended the crime to occur. He intended the crime of attempted robbery to occur when he armed himself, when he armed his co-defendant. He gave him the firearm. He gave him that 1911. And Madam Clerk, I'm going to ask that you pull that exhibit with the firearm of Jaden Fernandez holding the firearm. Thank you. And I'm going to get back to that in a moment. There's numerous parts of the evidence that you can look to decide whether the defendant intended for the crime to occur. Both girls testified that the car doors flew open and everybody jumped out, and that Thomas Stein immediately went toward Kayla. He didn't jump out confused, shocked about, oh my God, I didn't know that there was going to be an attempted robbery. I thought we were just getting the girls' numbers. That's a preposterous thing to believe. That's a forced doubt.
One second. I'm sorry.
Then agreeing to the defense, Judge.
Overruled.
It's preposterous to believe Thomas Stein's testimony that they were there to get girls' numbers. These men were armed with weapons, with firearms. They had masks, and they obviously had to have a conversation about what they were doing when those doors came open. To believe that Thomas was just this innocent, oblivious person going from car hopping to getting girls' numbers is a forced doubt. Defense made a deal about the testimony from Amy Schober, and she talked about the firearms and the Glock 27, and I would argue that's a very, very significant piece of evidence. And Amy Schober did testing, and she used Photoshop, but what did she tell you? She didn't alter or try to change the image. She locked it in so that she could make it the same size scale-wise to match the autopsy photo. And you saw the autopsy photo, the scale that showed that what they used to take those photographs, and then she used that same scale to make the firearm image fit the same scale as the wound. Now, defense said, well, she didn't do a very good job. She didn't look at the 1911. Well, you can look at the 1911 and you can see there's no lines on that firearm. There's no markings on the slide of that firearm that could be tested or compared with a wound. And not only that, you heard from both victims that the person with the red hooded sweatshirt and the white lettering that we know now to be Christopher Horn Jr., he didn't fire that gun. He had it pointed toward them. He never fired it. And then by Christopher Horn's testimony, he also indicated to you that he didn't fire the gun. And then Thomas Stein also said that Christopher Horn didn't fire the gun. So that leaves the Glock 27. And that's why, because of the way the evidence stacked, where we have Thomas Stein in a video with the Glock 27 belonging to his mom, that firearm was used to do an overlay to see if that would be consistent with the injuries near the bullet wound. And what else do we know about that firearm? Because Stein told you two completely different stories. First, he says, "Oh, I don't know where the Glock is." When my co-counsel was asking him on cross-examination, I thought it was in my mom's safe. And then 2 minutes later, when defense gets back up, he goes, "Oh yeah, I sold it." So you're telling me someone who didn't have any participation, who was the hero who tried to save Kayla's life that night, burns his clothes and gets rid of his mother's firearm by selling it within 48 hours. The reason that he and Christopher Horn got rid of the firearms after the murder is because they were used in the attempted robbery. They didn't get rid of them just for fun. They got rid of them because they're pieces of evidence in this case. And Jessica Stein told you, "I have no idea where the gun went. It was no longer in my house." And you heard Amy Schober say, the gun wasn't found. And now, today, Thomas Stein says, "Oh yeah, I sold it. I sold it on the same platform I used to sell all my drugs." Jaden's testimony, he talks about the statement that Christopher Horn made about robbing a Chico. Recall, the door was open when he's saying this, and he sees this gun. Jaden sees this gun. This is Jaden, but he sees this same gun that Thomas Stein stores at his house because the owner of the gun is in custody, and the owner of the gun is on probation and can't have a gun. So Thomas Stein stores it for his friend. That gun was in Christopher Horn's hand when he's saying, "Let's go rob a Chico." And defense wants to suggest to you that Thomas Stein never heard that, had no idea, didn't know anything about what they were going to do, that they were going to do anything bad that night. Defense went past Jessica Stein quickly because Jessica Stein is a problem for the defense. Jessica Stein testified that night she went into her room, so she didn't know what was going on. And she testified to you that prior to her going into her room, she saw Christopher Horn and she saw her son. Those are the only two people in her home that she saw. The only other person in this case that she saw that day was Jaden Fernandez when they went to the beach. She also stated that she doesn't know where the gun is. She also stated that what does she do with the car used in the murder? She gets rid of it the next day. What else does she tell you? She went to a park, not with JD or Trey. She goes to the park with her son, with Christopher Horn Jr., and with Christopher Horn's family to talk about how to get rid of the evidence. Both of those boys were involved, and the families got together because they needed a plan at how to avoid detection, how to avoid arrest. Jessica Stein knew what was going on, and she knew she had to assist in keeping her son from getting arrested. None of the elements that you'll see the state has to prove rely on Christopher Horn's testimony, which is why we didn't call him. We didn't need him as a witness in the case. Defense wants you to get sidetracked about the deal. And we know he wasn't a star witness. The state didn't call him. You have all the evidence you need to know that the defendant participated in a robbery. We also have Luann's testimony. And the defense mischaracterized her testimony that the state told her to say there's only two people. That never was a testimony. She was adamant from the beginning that there were 4 people. And it was frustrating because the detective was never able to put any other additional people on the scene. She came up and she told you the truth, and she told you what she remembers. The state doesn't have to prove how many people were there. I would suggest that the defense has tried to paint out Thomas Stein as a victim, that he's the one that's being used, that he has this nice house and nice family and everything he needs and everything's provided, and that Christopher Horn comes along and he's thuggish and his friends are thuggish. And because of that, they use Thomas Stein. And I would suggest, the evidence suggests otherwise. Thomas wasn't the victim of peer pressure. He's the drug dealer. He's the one with the guns. He's the one with the car. He's the one that with the mom that permitted him to smoke weed and play with guns. He's the bad influence. The defendant wants to make you think that getting rid of the evidence was Horn's idea. They both burned their clothes. They both got rid of the guns. And Stein couldn't keep his story straight about the guns from one moment to the next. This isn't a popularity contest. This isn't about who has money and who doesn't and who has a better family. This is about whether Thomas Stein, the only defendant sitting before you today, did some act or said something that was intended to and did incite, cause, encourage, assist, or advise the other persons or persons to actually commit, to attempt, or commit the crime. You saw the videos of Thomas Stein right before the murder. That wasn't a guy who was on his way to pick up chicks. Guns and masks are not how you pick up chicks. He didn't transition from car hopping that night to trying to pick up girls. Even if you feel that Christopher Horn Jr. is worse or seems like more of a criminal, it doesn't matter. Even if you think Thomas Stein was a follower that night, it doesn't matter. Not having the idea for the crime, not coming up with a plan, doesn't give you a pass. Nowhere in the instructions will you see that the state has to prove whose idea it was or when the idea came about. When he got out of that car, armed with a gun, and they were saying, give us your stuff, give us your shit, he was attempting to commit a robbery. You heard that it will be the judge's job to provide a sentence if the defendant is found guilty in this case. And if at any point you're in the back of those deliberation rooms and you feel sorry for the defendant or are concerned what might happen to him, you have already done your job. You have already found that he is guilty. Your job is to decide whether the state proved the charges beyond and to the exclusion of every reasonable doubt, and it's the judge's job to impose a sentence. The only people providing assistance that night were the people you saw here in court. Luann sat trying to stop the blood from Kayla, trying to stop her from bleeding out on the scene. She provided assistance. You heard from Emma. She provided assistance when she called 911. And you heard from Officers Vega. He and Houlihan were there first on scene and provided assistance to Kayla. And you heard from the officer, the lieutenant that went to Gulf Coast Hospital. And there were at least 20 people surrounding her, fighting for Kayla's life. Those were the people on March 17th that provided assistance to Kayla. Thomas Stein was not trying to provide assistance and break something up. He fled the scene as soon as she was shot, never to look back and only to work on getting rid of the evidence to make sure that he wasn't caught for the actions that he and the people that he was with did that night. Thomas Stein is not a victim in this case. Christopher Horn is not a victim. The victims are Emma Wright, Luann Deja, and Kayla Rincon-Miller. And we would ask that you find Thomas Stein guilty for his participation in the attempted robbery of the girls that night. And as a result of his behavior, as a result of committing a dangerous crime of robbery, he's guilty for everything that happened, whether you believe he pulled that trigger or not. So I ask that you hold Thomas Stein accountable for attempting to rob those girls. And in the course of that, the death of Kayla for first-degree felony murder and the attempted robberies of Kayla, Emma, and Luann. Thank you.
All right. So, ladies and gentlemen of the jury, I have, as been told to you, a fairly lengthy set of instructions to read to you. It is 1 o'clock. You have the option of me releasing you to let you all go to lunch and come back, and I can read the instructions to you. Or if you wish, I can take a short recess, let you go back to the jury room and order lunch to be delivered to you later and have you come right back out and read the instructions to you. I know you've been sitting here for a long time this morning, so my inclination would be to let you all go to lunch and then come back and I'd read the instructions to you. Is everybody okay with that? Okay. All right. Then it's very, very important, you remember my instructions. Don't look up anything. Don't discuss anything, even among yourselves, about this case or your jury service, and don't discuss that with anyone else. Does everybody understand the instructions? All right, I'm going to release you to lunch then. It's 1 o'clock. Please be back here by 2 o'clock.
All right. Okay, so the plan now is I'm going to go and start the other stream, the one in Ohio, and play that. I'm going to keep this stream going. I'm going to keep it up, but we'll come back to listen to the, what do you call it, to the charges and whatever, and stuff like that. So I'm going to try and go this. This stream's going to stay up. So if you're not interested in Ohio, just want to hear this, stay here, whatever. This will be up all the time. And then the other one, you might hear the other stream in this one, I'm not sure. But yeah, those of you want to go over to the Ohio one, have 2 streams open, that's fine. If you're in the Ohio one and something happens in this one, I'll let you know so we can jump back on to this one. If that sounds confusing, that's fine, whatever. But yeah, so we're going to do 2 streams same time. However, this is stopped. I'm going to stop this one and then come back to it once the Ohio one's done. We'll list the charges and see what happens. I'm going to make it up as I go along. If you don't like it, then I can't help you. Right, I'm going to start the other one, take myself off this one and go to the other one. I'll see you in a second.
robbery. The line between mere preparation and an overt act is a question of fact for you to decide. All right. So, ladies and gentlemen of the jury, I'm not able to follow the court.
Hello, how are you all back here? 4 of you are here anyway. I don't know which 4, but thank you for being here. 5, thank you for being here for somewhat of the time. Oh, how are we? How are we? 6. Hello, how are we doing, Patty? Rehab, how are you, my darling? Nice to see you. Hope you're doing well. Marky, did it work? Yes, it did work because you're over here. I'm not sure if it zoomed everyone else over or not. I don't know. But there you go. There's a couple of people here. I know some of you stayed here for both. I think I got the link in just... Oh, don't worry about it. It's fine. It's fine. It's fine. People know where we are, so it's fine. No. Oh, no. No way. I came over. There you go. That's what I mean. Everyone knows where we are. So, do you know what's funny, right? Let me see if I can see this. Before I play this, let me see if I can get this. So obviously got the trial open for Stefan Diggs. Let me see if I can do this. Just to see, keep an eye out for it, you know. So the first witness is up on that one. Look who's in the chat over there. Can you see it? There he is. Dave Umberger. He controls the narrative, he says. That's where it's gone up now. But this is Dave. I'm not watching it. I'm not watching it, by the way. I generally am not watching it. I've not heard one word of it. I have it up just in the sense of knowing where things are. Like, so the openings were like 40 minutes. This was whatever. So that's why I have it open. And I opened it to see, right, is there a witness on? And the first thing I see, Dave Umberger in chat. Dave is in the streets running. Dave is busted, yes. This is why I said, I warned him, if he spoils anything, he's out. So, you should have full more. Literally, you're not missing anything from what I gather. They've only just probably 15 minutes ago start with the first witness. So you're all good. Genuinely, you're all good. Hello, lovely. How are you? Nice to see you again. You'll be fine, Josie. You honestly will be fine. Right. Let's go back here now then. This is the jury charges. And the reason I'm not playing it live is because I've got, obviously, these to play as well. So, I mean, I can't juggle 3 trials. That's the issue I'm having, you know. So, I was commenting on the other chat and you could see me here. Weird. Right, I'm going to make some dinner now whilst you listen to the charges here. So here we go.
Instructions about doing any research, looking up anything, or discussing anything about their services if you're on the case. Seeing your hands and ready to proceed. Now, these instructions are 71 pages long. They're not all full pages, but it's going to take some time. If at some time, if somebody needs a break or anything like that, let me know. If I'll be trying to read and look up at you at different times. But if for some reason I don't see you raise your hand, let Mike know, and he'll let me know if anybody needs a break. Okay? And I'll let you know if I need a break. All right? All right. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Statement of charge. Thomas Stein, the defendant in this case, has been accused of the crimes of first-degree felony murder and 3 counts of attempted robbery. Introduction to homicide. And also, before I go on, I'm reading these to you. You will get a copy of these to go back with you as well. All right. Introduction to homicide. Thomas Stein is accused of first-degree felony murder. First-degree felony murder includes the lesser crimes of second-degree murder and manslaughter, all of which are unlawful. However, a killing that was excusable homicide or that was committed by the justifiable use of deadly force is lawful. If you find Kayla Rincon-Miller was killed by Thomas Stein, you will then consider the circumstances surrounding the killing and deciding if the killing was second-degree murder or manslaughter, or whether the killing was excusable homicide or resulted from the justifiable use of deadly force. Justifiable homicide. The use of deadly force to kill a human being is justifiable homicide and therefore lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in or upon any dwelling house in which the defendant was at the time of the killing. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means harm that is more than slight, trivial, minor, or moderate. Excusable homicide. The killing of a human being is excusable homicide and therefore lawful under any one of the following three circumstances. 1, when the killing is committed by an accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. Count 1, first-degree felony murder. To prove the crime of first-degree felony murder, the state must prove the following three elements beyond a reasonable doubt. 1, Kayla Christina Rincon-Miller is dead. 2, while engaged in the attempt to commit a robbery, Thomas Stein or Thomas Stein's accomplice caused the death of Kayla Christina Rincon-Miller. 3, Thomas Stein was the person who actually killed Kayla Christina Rincon-Miller, or Kayla Christina Rincon-Miller was killed by a person other than Thomas Stein, but both Thomas Stein and the person who killed Christina Rincon-Miller were principals in the commission of attempted robbery. To convict the defendant of first-degree felony murder, it is not necessary for the state to prove the defendant had a premeditated design or an intent to kill. Robbery is defined as 1, Thomas Stein took a purse from the person or custody of Kayla Christina Rincon-Miller. 2, force, violence, assault, or putting in fear was used in the course of the taking. 3, the property was of some value. 4, the taking was with the intent to permanently or temporarily deprive Kayla Christina Rincon-Miller of her right to the property or any benefit from it, or appropriate the property of Kayla Christina Rincon-Miller to her own use or to the use of any person not entitled to it. Attempt is defined as 1, Thomas Stein intended to commit the crime of robbery. 2, Thomas Stein committed an overt act toward the commission of a robbery that went beyond mere preparation. 3, Thomas Stein failed to complete the robbery. The line between mere preparation and an overt act is a question of fact for you to decide. Mere preparation consists of devising or arranging the means or measures necessary to commit the crime. An overt act consists of some movement toward committing the crime after mere preparation. An overt act need not be the last possible act toward completing the crime. Principles. If the defendant helped another person or persons commit or attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if the state proved beyond a reasonable doubt, 1, the defendant intended the crime to occur, and 2, the defendant did some act or said something that was intended to and that did incite, cause, encourage, assist, or advise the other person or persons to actually commit or attempt to commit the crime. It is not necessary for a principal to know every detail of how a first-degree felony murder will be committed as long as the principal intended the first-degree felony murder to occur and did some act or said something that was intended to help and did help the first-degree felony murder to occur. To be found guilty of robbery or attempted robbery with a firearm as a principal, it is not necessary for the state to prove a defendant knew another participant of the robbery or attempted robbery was armed. However, mere knowledge that the underlying attempted robbery is being committed and mere presence at the scene is not sufficient to establish that Thomas Stein is a principal to first-degree felony murder. If you find the defendant guilty of first-degree felony murder, you must also determine whether the state proved beyond a reasonable doubt that he actually killed, intended to kill, or attempted to kill Kayla Christina Rincon-Miller. Independent act. If you find that the crime alleged was committed, an issue in this case is whether the crime of first-degree felony murder was an independent act of a person other than the defendant. An independent act occurs when a person other than the defendant commits or attempts to commit a crime. 1, which the defendant did not intend to occur, and 2, in which the defendant did not participate, and 3, which was outside of and not reasonably foreseeable consequence of the common design or unlawful act contemplated by the defendant. If you find the defendant was not present when the crime of first-degree felony murder occurred, that in and of itself does not establish that the first-degree felony murder was an independent act of another. If you find that the first-degree felony murder was an independent act of another person, then you should find Thomas Stein not guilty of the crime of first-degree felony murder. Aggravation of first-degree felony murder by carrying, displaying, or using a firearm. If you find that Thomas Stein committed first-degree felony murder, you must then determine whether it has been proven beyond a reasonable doubt that during the commission of the crime, he personally carried, displayed, or used a firearm. A firearm is defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive, the frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. The term firearm does not include an antique firearm unless the antique firearm is used in the commission of a crime. Possession of a firearm and discharge causing death. If you find that Thomas Stein committed first-degree felony murder, you must then determine whether it's been proven beyond a reasonable doubt that 1. During the commission of the crime, Thomas Stein actually possessed a firearm, 2. During the commission of the crime, Thomas Stein discharged a firearm, and 3. During the commission of the crime, Thomas Stein discharged a firearm and in doing so caused the death of Kayla Christina Rincon-Miller. A firearm is legally defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive. The term firearm does not include an antique firearm unless the antique firearm is used in the commission of a crime. To actually possess a firearm means that the defendant, A, carried a firearm on his person, or B, had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. Lesser included crimes. If the evidence does not convince you that the defendant committed the main crimes of which he is accused, there may be sufficient evidence that he committed a lesser included crime. In other words, if you decide the main accusation has not been proved beyond a reasonable doubt that the defendant is guilty of, in other words, if you decide the main accusation has not been proved beyond a reasonable doubt that the defendant is guilty of a lesser included crime, the lesser, I'm not sure how to reach right. The lesser included crimes of first-degree felony murder are second-degree murder and manslaughter. Count 1, lesser included crime, second-degree murder. To prove the crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Kayla Christina Rincon-Miller is dead. 2, the death was caused by the criminal act of Thomas Stein. 3, there was an unlawful killing of Kayla Christina Rincon-Miller by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another and demonstrating a depraved mind if it is an act or a series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. To convict of second-degree murder, it is not necessary for the state to prove that the defendant had an intent to cause death. If you find Thomas Stein guilty of second-degree murder, you must also determine whether the state proved beyond a reasonable doubt that he actually killed, intended to kill, or attempted to kill Kayla Christina Rincon-Miller. Aggravation of second-degree murder by carrying, displaying, or using a firearm. If you find that Thomas Stein committed second-degree murder, you must then determine whether it has been proven beyond a reasonable doubt that during the commission of the crime, he personally carried, displayed, or used a firearm. A firearm is defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive, the frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. The term firearm does not include an antique firearm unless the antique firearm is used in the commission of a crime. Possession of a firearm and discharge causing death. If you find that Thomas Stein committed second-degree murder, you must then determine whether it has proven beyond a reasonable doubt that 1, during the commission of the crime, Thomas Stein actually possessed a firearm. 2, during the commission of the crime, Thomas Stein discharged a firearm. And 3, during the commission of the crime, Thomas Stein discharged a firearm and in doing so caused the death of Kayla Christina Rincon-Miller. A firearm is legally defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive. The term firearm does not include an antique firearm unless the antique firearm is used in the commission of a crime. To actually possess a firearm means the defendant, A, carried a firearm on his person, or B, had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. Principles. If the defendant helped another person or persons commit or attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if the state proved beyond a reasonable doubt, 1, the defendant intended the crime to occur, and 2, the defendant did some act or said something that was intended to and that did incite, cause, encourage, assist, or advise the other person or persons to actually commit or attempt to commit the crime. For second-degree murder, it is not necessary for the state to prove the defendant intended the death of Kayla Christina Rincon-Miller. It is not necessary for a principal to know every detail of how second-degree murder will be committed, as long as the principal intended the second-degree murder to occur and did some act or said something that was intended to help and did help the second-degree murder occur. However, mere knowledge that the underlying attempted robbery is being committed and mere presence at the scene is not sufficient to establish that Thomas Stein is a principal to second-degree murder. Independent act. If you find that the crime alleged was committed, an issue in this case is whether the crime of second-degree murder was an independent act of a person other than the defendant. An independent act occurs when a person other than the defendant commits or attempts to commit a crime. 1, which the defendant did not intend to occur, and 2, in which the defendant did not participate, and 3, which was outside of and not a reasonably foreseeable consequence of the common design or unlawful act contemplated by the defendant. If you find the defendant was not present when the crime of second-degree murder occurred, that in and of itself does not establish that the second-degree murder was an independent act of another. If you find that the second-degree murder was an independent act of another person, then you should find Thomas Stein not guilty of the crime of second-degree murder. Count 1, lesser included crime, manslaughter. To prove the crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. 1, Kayla Christina Rincon-Miller is dead. 2, Thomas Stein intentionally committed an act or acts that caused the death of Kayla Christina Rincon-Miller. Every person has the duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. To convict of manslaughter, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. Principles. If the defendant helped another person or persons commit or attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if the state proved beyond a reasonable doubt, 1, the defendant intended the crime to occur, and 2, the defendant did some act or said something that was intended to and it did incite, cause, encourage, assist, or advise the other person or persons to actually commit or attempt to commit the crime. However, mere knowledge that the underlying manslaughter is being committed and mere presence at the scene is not sufficient to establish that Thomas Stein is a principal to manslaughter. Independent act. If you find that the crime alleged was committed, an issue in this case is whether the crime of manslaughter was an independent act of a person other than the defendant. An independent act occurs when a person other than the defendant commits or attempts to commit a crime. 1, which the defendant did not intend to occur, and 2, in which the defendant did not participate, and 3, which was outside of and not a reasonably foreseeable consequence of the common design or unlawful act contemplated by the defendant. If you find that the defendant was not present when the crime of manslaughter occurred, in and of itself does not establish that the manslaughter was an independent act of another. If you find that the manslaughter was an independent act of another person, then you should find Thomas Stein not guilty of the crime of manslaughter. Aggravation of manslaughter by carrying, displaying, or using a firearm. If you find that Thomas Stein committed manslaughter, you must then determine whether it has been proven beyond a reasonable doubt that during the commission of the crime, he personally carried, displayed, or used a firearm. A firearm is defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive, the frame or receiver of any such weapon, any firearm muffler, firearm silencer, any destructive device, or any machine gun. The term firearm does not include an antique firearm unless the antique firearm is used in the commission of a crime. Count 2, attempted robbery. Kayla Christina Rincon-Miller. To prove Thomas Stein attempted to commit the crime of robbery, the state must prove the following 3 elements beyond a reasonable doubt. 1, Thomas Stein intended to commit the crime of robbery. 2, Thomas Stein committed an overt act toward the commission of robbery that went beyond mere preparation. 3, Thomas Stein failed to complete the robbery. The line between mere preparation and an overt act is a question of fact for you to decide. Mere preparation consists of devising or arranging the means or measures necessary to commit the crime. An overt act consists of some movement toward committing the crime after mere preparation. An overt act need not be the last possible act toward completing the crime. To prove the crime of robbery, the state must prove the following 4 elements beyond a reasonable doubt. 1, Thomas Stein took a purse from the personal custody of Kayla Christina Rincon-Miller. 2, force, violence, assault, or putting in fear was used in the course of the taking. 3, the property taken was of some value. 4, the taking was with the intent to permanently or temporarily deprive Kayla Christina Rincon-Miller of her right to the property or any benefit from it, or appropriate the property of Kayla Christina Rincon-Miller to your own use or to the use of any other person not entitled to it. An assault is an intentional and unlawful threat, either by word or act, to do violence to a victim. When it appears the person making the threat has the ability to carry out the threat, and the act creates in the mind of that victim a well-founded fear that violence is about to take place. If the circumstances were such as to ordinarily induce fear in the mind of a reasonable person, then a victim may be found to have been in fear, and actual fear on the part of the victim need not be shown. In the course of the taking means the act occurred prior to, contemporaneous with, or subsequent to the taking of the property, and that the act and the taking of the property constitute a continuous series of acts or events. The taking must be by the use of force or violence so as to overcome the resistance of a person, or by putting a person in fear so that he or she does not resist. The law does not require the force, violence, assault, or putting in fear to be exerted against the victim from whom the property was taken if the force, violence, assault, or putting in fear was exerted against another in the course of the taking. The law does not require that a victim of robbery resist to any particular extent, or that a victim offer any actual physical resistance if the circumstances are such that a victim is placed in fear of death or great bodily harm if he or she does resist. But unless prevented by fear, there must be some resistance to make the taking one done by force or violence. In order for a taking by force, violence, or putting in fear to be robbery, it is not necessary that the taking be from the person of the victim. It is sufficient if the property taken is under the custody of the victim, so that it cannot be taken without the use of force, violence, or intimidation directed against the victim. If you find the defendant guilty of the crime of robbery, you must further determine beyond a reasonable doubt if, in the course of committing the robbery, the defendant carried some kind of weapon. An act is in the course of committing the robbery if it occurs in an attempt to commit robbery or in flight after the attempt or commission. If you find the defendant carried a firearm in the course of committing the robbery, you should find him guilty of robbery with a firearm. A firearm means any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive. If you find that the defendant carried a weapon that was not a firearm in the course of committing the robbery, you should find him guilty of robbery with a weapon. A weapon is any object other than a firearm that will likely cause bodily harm if used in the ordinary and usual manner contemplated by its design and construction. If you find the defendant carried no firearm or weapon in the course of committing the robbery, but did commit the robbery, you should find him guilty only of robbery. Possession of a firearm. If you find that Thomas Stein committed attempted robbery, you must then determine whether it has been proven beyond a reasonable doubt that during the commission of the crime, he actually possessed a firearm. A firearm is legally defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive. The term firearm does not include an antique firearm unless the antique firearm is used in the commission of a crime. To actually possess a firearm means that the defendant, A, carried a firearm on his person, or B, had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. Principles. If the defendant helped another person or persons commit or attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if the state proved beyond a reasonable doubt, 1, the defendant intended the crime to occur, and 2, the defendant did some act or said something that was intended to and that did incite, cause, encourage, assist, or advise the other person or persons to actually commit or attempt to commit the crime. However, mere knowledge that the underlying attempted robbery is being committed and the mere presence at the scene is not sufficient to establish that Thomas Stein is a principal to attempted robbery. Independent act. If you find that the crime alleged was committed, an issue in this case is whether the crime attempted robbery was an independent act of a person other than the defendant. An independent act occurs when a person other than the defendant commits or attempts to commit a crime. 1, which the defendant did not intend to occur, and 2, in which the defendant did not participate, and 3, which was outside of and not a reasonably foreseeable consequence of the common design or unlawful act contemplated by the defendant. If you find the defendant was not present when the crime of attempted robbery occurred, that in and of itself does not establish that the attempted robbery was not an independent act of another, or was an independent act of another. If you find that the attempted robbery was an independent act of another person, then you should find Thomas Stein not guilty of the crime of attempted robbery. Lesser included crimes. If the evidence does not convince you that the defendant committed the main crime of which he is accused, there may be sufficient evidence that he committed a lesser included crime. In other words, if you decide the main accusation has not been proved beyond a reasonable doubt, you will need to decide if the state proved beyond a reasonable doubt that the defendant is guilty of a lesser included crime. The lesser included crime of attempted robbery are theft and assault. Count 2, lesser included crime, theft. To prove the crime of theft, the state must prove the following 2 elements beyond a reasonable doubt. 1, Thomas Stein knowingly and unlawfully endeavored to obtain or use the purse or property of Kayla Rincon-Miller. 2, he did so with intent to either temporarily or permanently deprive Kayla Christina Rincon-Miller of her right to the property or any benefit from it. Proof of possession of recently stolen property, unless satisfactorily explained, gives rise to an inference that the person in possession of the property knew or should have known that the property had been stolen. Obtains or uses means any manner or taking or exercising control over property. Endeavor means to attempt or try. Property means anything of value. Principles. If the defendant helped another person or persons commit or attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if the state proved beyond a reasonable doubt, 1, the defendant intended the crime to occur, and 2, the defendant did some act or said something that was intended to and did incite, cause, encourage, assist, or advise the other person or persons to actually commit or attempt to commit the crime. However, mere knowledge that the underlying theft is being committed and mere presence at the scene is not sufficient to establish that Thomas Stein is a principal to theft. Independent act. If you find that the crime alleged was committed, an issue in this case is whether the crime of theft was an independent act of a person other than the defendant. An independent act occurs when a person other than the defendant commits or attempts to commit a crime. 1, which the defendant did not intend to occur, and 2, in which the defendant did not participate, and 3, which was outside of and not a reasonably foreseeable consequence of the common design or unlawful act contemplated by the defendant. You find the defendant was not present when the crime of theft occurred. That in and of itself does not establish that the theft was an independent act of another. You find that the theft was an independent act of another person, then you should find Thomas Stein not guilty of the crime of theft. Count 2, lesser included crime, assault. To prove the crime of assault, the state must prove the following 3 elements beyond a reasonable doubt. 1, Thomas Stein intentionally and unlawfully threatened, either by word or act, to do violence to Kayla Christina Rincon-Miller. 2, at the time, Thomas Stein appeared to have the ability to carry out the threat. 3, the act of Thomas Stein created in the mind of Kayla Christina Rincon-Miller a well-founded fear that violence was about to take place. Principles. If the defendant helped another person or persons commit or attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if the state proved beyond a reasonable doubt, 1, the defendant intended the crime to occur, and 2, the defendant did some act or said something that was intended to and that did incite, cause, encourage, assist, or advise the other person or persons to actually commit or attempt to commit the crime. However, mere knowledge that the underlying assault is being committed and mere presence at the scene is not sufficient to establish that Thomas Stein is a principal to assault. Independent act. If you find that the crime alleged was committed, an issue in this case is whether the crime of assault was an independent act of a person other than the defendant. An independent act occurs when a person other than the defendant commits or attempts to commit a crime, 1, which the defendant did not intend to occur, and 2, in which the defendant did not participate, and 3, which was outside of and not a reasonably foreseeable consequence of the common design or unlawful act contemplated by the defendant. If you find the defendant was not present when the crime of assault occurred, that in and of itself does not establish that the assault was an independent act of another. If you find that the assault was an independent act of another person, then you should find Thomas Stein not guilty of the crime of assault. Count 3, attempted robbery, Luann Dejay. To prove Thomas Stein attempted to commit the crime of robbery, the state must prove the following 3 elements beyond a reasonable doubt. 1, Thomas Stein intended to commit the crime of robbery. 2, Thomas Stein committed an overt act toward the commission of robbery that went beyond mere preparation. 3, Thomas Stein failed to complete the robbery. The line between mere preparation and an overt act is a question of fact for you to decide. Mere preparation consists of devising or arranging the means or measures necessary to commit the crime. An overt act consists of some movement toward committing the crime after mere preparation. An overt act need not be the last possible act toward completing the crime. To prove the crime of robbery, the state must prove the following 4 elements beyond a reasonable doubt. 1, Thomas Stein took a purse from the person or custody of Luann Dejay. 2, force, violence, assault, or putting in fear was used in the course of the taking. 3, the property taken was of some value. 4, the taking was with the intent to permanently or temporarily deprive Luann Dejay of her right to the property or any benefit from it, or appropriate the property of Luann Dejay to her own use or for the use of any person not entitled to it. An assault is an intentional and unlawful threat, either by word or act, to do violence to the victim when it appears the person making the threat has the ability to carry out the threat, and the act creates in the mind of that victim a well-founded fear that violence is about to take place. If the circumstances were such as to ordinarily induce fear in the mind of a reasonable person, then a victim may be found to have been in fear, and actual fear on the part of the victim need not be shown. In the course of the taking means that the act occurred prior to, contemporaneous with, or subsequent to the taking of the property, and that the act and the taking of the property constitute a continuous series of acts or events. The taking must be by the use of force or violence so as to overcome the resistance of a person, or by putting a person in fear so that he or she does not resist. The law does not require the force, violence, assault, or putting in fear to be exerted against the victim from whom the property was taken if the force, violence, assault, or putting in fear was exerted against another in the course of the taking. The law does not require that a victim of robbery resist to any particular extent, or that a victim offer any actual physical resistance if the circumstances are such that a victim is placed in fear of death or great bodily harm if he or she does resist. But unless prevented by fear, there must be some resistance to making the taking one done by force or violence. In order for a taking by force, violence, or putting in fear to be robbery, it is not necessary that the taking be from the person of the victim. It is sufficient if the property taken is under the custody of a victim so that it cannot be taken without the use of force, violence, or intimidation directed against the victim. If you find the defendant guilty of the crime of robbery, you must further determine beyond a reasonable doubt if, in the course of committing the robbery, the defendant carried some kind of weapon. An act is in the course of committing the robbery if it occurs in an attempt to commit robbery or in flight after the attempt or commission. If you find the defendant carried a firearm in the course of committing the robbery, you should find him guilty of robbery with a firearm. A firearm means any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive. If you find the defendant carried a weapon that was not a firearm in the course of committing the robbery, you should find him guilty of robbery with a weapon. A weapon is any object other than a firearm that will likely cause bodily harm if used in the ordinary and usual manner contemplated by its design and construction. If you find the defendant carried no firearm or weapon in the course of committing the robbery, but did commit the robbery, you should find him guilty only of robbery. Possession of the firearm. If you find that Thomas Stein committed attempted robbery, you must then determine whether it's been proven beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm. A firearm is legally defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive. The term firearm does not include an antique firearm unless the antique firearm is used in the commission of a crime. To actually possess a firearm means that the defendant, A, carried a firearm on his person, or B, had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. Principles. If the defendant helped another person or persons commit or attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if the state proved beyond a reasonable doubt. 1, the defendant intended the crime to occur, and 2, the defendant did some act or said something that it was intended to and that did incite, cause, encourage, assist, or advise the other person or persons to actually commit or attempt to commit the crime. However, mere knowledge that an underlying attempted robbery is being committed and mere presence at the scene is not sufficient to establish that Thomas Stein is a principal to attempted robbery. Independent act. If you find that the crime alleged was committed, an issue in this case is whether the crime of attempted robbery was an independent act of a person other than the defendant. An independent act occurs when a person other than the defendant commits or attempts to commit a crime. 1, which the defendant did not intend to occur, and 2, in which the defendant did not participate, and 3, which was outside of and not a reasonably foreseeable consequence of the common design or unlawful act contemplated by the defendant. If you find the defendant was not present during the crime of attempted robbery occurred, that in and of itself does not establish that the attempted robbery was an independent act of another. If you find that the attempted robbery was an independent act of another person, then you should find Thomas Stein not guilty of the crime of attempted robbery. Lesser included crimes. If the evidence does not convince you that the defendant committed the main crime of which he is accused, there may be sufficient evidence that he committed a lesser included crime. In other words, if you decide the main accusation has not been proved beyond a reasonable doubt, you will need to decide in the state proved beyond a reasonable doubt that the defendant is guilty of a lesser included crime. The lesser included crime of attempted robbery are theft and assault. Count 3, lesser included crime, theft. To prove the crime of theft, the state must prove the following 2 elements beyond a reasonable doubt. 1, Thomas Stein knowingly and unlawfully endeavored to obtain or use the purse or property of Luann Dejay. 2, he did so with intent to either temporarily or permanently deprive Luann Dejay of her right to the property or any benefit from it. Proof of possession of recently stolen property, unless satisfactorily explained, gives rise to an inference that the person in possession of the property knew or should have known that the property had been stolen. Obtains or uses means any manner of taking or exercising control over property. Endeavor means to try, attempt, or try. Property means anything of value. Principles. If the defendant helped another person or persons commit or attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if the state proved beyond a reasonable doubt, 1, the defendant intended the crime to occur, and 2, the defendant did some act or said something that was intended to and that it did incite, cause, encourage, assist, or advise the other person or persons to actually commit or attempt to commit the crime. However, mere knowledge that the underlying theft is being committed and mere presence at the scene is not sufficient to establish that Thomas Stein is a principal to theft. Independent act. If you find that the crime alleged was committed, an issue in this case is whether the crime of theft was an independent act of a person other than the defendant. An independent act occurs when a person other than the defendant commits or attempts to commit a crime. 1, which the defendant did not intend to occur, and 2, in which the defendant did not participate, and 3, which was outside of and not a reasonably foreseeable consequence of the common design or unlawful act contemplated by the defendant. If you find the defendant was not present when the crime of theft occurred, that in and of itself does not establish that the theft was an independent act of another. If you find that the theft was an independent act of another person, then you should find Thomas Stein not guilty of the crime of theft. Count 3, lesser included crime, assault. To prove the crime of assault, the state must prove the following 3 elements beyond a reasonable doubt. 1, Thomas Stein intentionally and unlawfully threatened, either by word or act, to do violence to Luann Dejay. 2, at the time, Thomas Stein appeared to have the ability to carry out the threat. 3, the act of Thomas Stein created in the mind of Luann Dejay a well-founded fear that the violence was about to take place. Principles. If the defendant helped another person or persons commit or attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if the state proved beyond a reasonable doubt, 1, the defendant intended the crime to occur, and 2, the defendant did some act or said something that was intended to and that did incite, cause, encourage, assist, or advise the other person or persons to actually commit or attempt to commit the crime. However, mere knowledge that the underlying assault is being committed and mere presence at the scene is not sufficient to establish that Thomas Stein is a principal to assault. Independent act. If you find that the crime alleged was committed, an issue in this case is whether the crime of assault was an independent act of a person other than the defendant. An independent act occurs when a person other than the defendant commits or attempts to commit a crime. 1, which the defendant did not intend to occur, and 2, in which the defendant did not participate, and 3, which was outside of and not a reasonably foreseeable consequence of the common design or unlawful act contemplated by the defendant. If you find the defendant was not present when the crime of assault occurred, that in and of itself does not establish that the assault was an independent act of another. If you find that the assault was an independent act of another person, then you should find Thomas Stein not guilty of the crime of assault. Count 4, attempted robbery, Emma Wright. To prove Thomas Stein attempted to commit the crime of robbery, the state must prove the following 3 elements beyond a reasonable doubt. 1, Thomas Stein intended to commit the crime of robbery. 2, Thomas Stein committed an overt act toward the commission of robbery that went beyond mere preparation. 3, Thomas Stein failed to complete the robbery. The line between mere preparation and an overt act is a question of fact for you to decide. Mere preparation consists of devising, arranging the means or measures necessary to commit the crime. An overt act consists of some movement toward committing the crime after mere preparation. An overt act need not be the last possible act toward the completing the crime. To prove the crime of robbery, the state must prove the following 4 elements beyond a reasonable doubt. 1, Thomas Stein took a purse from the person or custody of Emma Wright. 2, force, violence, assault, or putting in fear was used in the course of the taking. 3, the property taken was of some value. 4, the taking was with the intent to permanently or temporarily deprive Emma Wright of her right to the property or any benefit from it, or appropriate the property of Emma Wright to her own use or to the use of any other person not entitled to it. An assault is an intentional and unlawful threat, either by word or act, to do violence to a victim. When it appears the person making the threat has the ability to carry out the threat, and the act creates in the mind of that victim a well-founded fear that violence is about to take place. If the circumstances were such as to ordinarily induce fear in the mind of a reasonable person, then a victim may be found to have been in fear, and actual fear on the part of the victim need not be shown. In the course of the taking means the act occurred prior to, contemporaneous with, or subsequent to the taking of the property, and that the act and the taking of the property constitute a series of acts or events. The taking must be by the use of force or violence so as to overcome the resistance of a person, or by putting a person in fear so that he or she does not resist. The law does not require the force, violence, assault, or putting in fear to be exerted against the victim from whom the property was taken if the force, violence, assault, or putting in fear was exerted against another in the course of the taking. The law does not require that a victim of robbery resist to any particular extent, or that a victim offer any actual physical resistance if the circumstances are such that a victim is placed in fear of death or great bodily harm if he or she does resist. But unless prevented by fear, there must be some resistance to make the taking one done by force or violence. In order for a taking by force, violence, or putting in fear to be robbery, it is not necessary that the taking be from the person of the victim. It is sufficient if the property taken is under the custody of the victim so that it cannot be taken without the use of force, violence, or intimidation directed against the victim. If you find the defendant guilty of the crime of robbery, you must further determine beyond a reasonable doubt if, in the course of committing the robbery, the defendant carried some kind of weapon. An act is in the course of committing robbery if it occurs in an attempt to commit robbery or in flight after the attempt or commission. If you find the defendant carried a firearm in the course of committing the robbery, you should find him guilty with a firearm. A firearm means any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive. If you find that the defendant carried a weapon that was not a firearm in the course of committing the robbery, you should find him guilty of robbery with a weapon. A weapon is any object other than a firearm that will likely cause bodily harm if used in the ordinary and usual manner contemplated by its design and construction. If you find the defendant carried no firearm or weapon in the course of committing the robbery but did commit the robbery, you should find him guilty only of robbery. Possession of a firearm. If you find that Thomas Stein committed attempted robbery, you must then determine whether it has been proven beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm. A firearm is legally defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive. The term firearm does not include an antique firearm unless the antique firearm is used in the commission of the crime. To actually possess a firearm means that the defendant, A, carried a firearm on his person, or B, had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. If the defendant helped another person or persons commit or attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if the state proved beyond a reasonable doubt, 1, the defendant intended the crime to occur, and 2, the defendant did some act or said something that was intended to and that did incite, cause, encourage, assist, or advise the other person or persons to actually commit or attempt to commit the crime. However, mere knowledge that the underlying attempted robbery is being committed and mere presence at the scene is not sufficient to establish that Thomas Stein is a principal to attempted robbery. Independent act. If you find that the crime alleged was committed, an issue in this case is whether the crime of attempted robbery was an independent act of a person other than the defendant. An independent act occurs when a person other than the defendant commits or attempts to commit a crime. 1, when the defendant did not intend to occur, and 2, in which the defendant did not participate, and 3, which was outside of and not a reasonably foreseeable consequence of the common design or unlawful act contemplated by the defendant. If you find the defendant was not present when the crime of attempted robbery occurred, that in and of itself does not establish the attempted robbery was an independent act of another. If you find that the attempted robbery was an independent act of another person, then you should find Thomas Stein not guilty of the crime of attempted robbery. Lesser included crime. Versus Thomas Stein, case number 24 CF 000272, special finding as to manslaughter. If you found the defendant guilty of manslaughter, you must then answer the following question. Do you unanimously find beyond a reasonable doubt that during the commission of the crime, the defendant personally carried, displayed, or used a firearm? Yes, no. So say we all, in place for the date, 4-person signature, and for the 4-person to print their name. In the Circuit Court of the 20th Judicial Circuit in and for Lee County, Florida, criminal action, State of Florida versus Thomas Stein, case number 24 CF 000272, special finding as to count 2, attempted robbery, Kayla Rincon-Miller. If you found the defendant guilty of attempted robbery, you must then answer the following question. Do you unanimously find beyond a reasonable doubt that during the commission of the crime, the defendant actually possessed a firearm? Yes, no. So say we all, in a place for the date, 4-person signature, and 4-person to print their name. In the Circuit Court of the 20th Judicial Circuit in and for Lee County, Florida, criminal action, State of Florida versus Thomas Stein, Case number 24CF000272. Special finding as to count 3 attempted robbery, Luann DeJay. If you found the defendant guilty of attempted robbery, you must then answer the following question. Do you unanimously find beyond a reasonable doubt that during the commission of the crime, the defendant actually possessed a firearm? Yes, no. So say we all, place for the date for the four-person signature and to print their name. In the Circuit Court of the 20th Judicial Circuit in and for Lee County, Florida, criminal action, State of Florida versus Thomas Stein. Case number 24CF000272. Special finding as to count 4 attempted robbery, Emma Wright. If you found the defendant guilty of attempted robbery, you must then answer the following question. Do you unanimously find beyond a reasonable doubt that during the commission of the crime, the defendant actually possessed a firearm? Yes, no. So say we all. Again, place for the date, for the four-person signature, and the four-person to print their name. Single defendant, multiple counts. A separate crime is charged in each count of the information or indictment. And although they have been tried together, each crime, the evidence applicable to it, must be considered separately and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. Legally interlocking counts as to first-degree felony murder. Counts 1, 2, 3, and 4 are linked in that the crime charged in counts 2, 3, and 4, attempted robbery, is an essential element of the crime charged in count 1 as the first-degree felony murder. You should first consider the evidence applicable to count 2, attempted robbery, as to Kayla Rincon-Miller. You should then consider the evidence applicable to count 3, attempted robbery, as to Luann DeJay. You should then consider the evidence applicable to count 4, attempted robbery, as to Emma Wright. If you find the crime in count 2, 3, or 4, attempted robbery, has not been proven beyond a reasonable doubt, you must find the defendant not guilty on counts 1 as to first-degree felony murder. If, on the other hand, if you find the crime charged in count 2, attempted robbery, as to Kayla Rincon-Miller, count 3, attempted robbery, as to Luann DeJay, or count 4, attempted robbery, as to Emma Wright, has been proven beyond a reasonable doubt, you must then consider the evidence applicable to count 1, first-degree felony murder. A guilty verdict on count 2, attempted robbery, as to Kayla Rincon-Miller, count 3, attempted robbery to Luann DeJay, or count 4, attempted robbery, as to Emma Wright, does not require a guilty verdict on count 1, first-degree felony murder. You should find the defendant guilty on count 1, first-degree felony murder, only if you find all the elements of that crime, including the essential elements contained in attempted robbery, as to Kayla Rincon-Miller, count 3, attempted robbery, as to Luann DeJay, or count 4, attempted robbery, as to Emma Wright, were proven beyond a reasonable doubt. Submitting case to jury. In just a few moments, you will be taken to the jury room by the court deputy or bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict forms when all of you have agreed on a verdict and to bring the verdict forms back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberations should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as email or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the court deputy or bailiff. Many of you have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the court deputy or bailiff while you deliberate. If you need to communicate with me, send a note through the court deputy or bailiff. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. During the trial, items are received as evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. Most of these exhibits will be sent into the jury room with you when you begin to deliberate. If you wish to see any exhibits not sent back into the jury room, please request that in writing. In closing, let me remind you that it is important that you follow the laws spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules we all share. So with that, ladies and gentlemen, you can take your notebooks, and everyone except juror 77 and juror 29 may retire to begin your deliberations and take your notes. And juror 77 and 29, Christian Reagan. You can get out and stand here, but just don't go back. The record reflects jury says the court made objections to the instructions as read. Okay. All right. So you all are the alternate jurors. We don't tell people who the alternates are to the very end. We want everybody to pay equal attention. Your service is equally appreciated. When everyone had something come up and not be able to deliberate, you would be back here right now. It would be necessary for you. So again, we thank you again for your service. Leave your notebooks here. I'll destroy your notes. And if you have any belongings back there, we'll have Mike when he comes out. He'll go back and you just tell him what you have back there. He'll get it, bring it out to you. You are excused for the remainder of the year for your jury service. And you have the right to either talk about your service or not talk about it. And so I'll leave that up to you. If you wish not to talk about your service and someone continues to ask you or is bothering you about that, tell a bailiff and I'll take care of it, okay, if you don't want to talk about it. All right? Just wait for a moment, let Mike come out and we'll get you your stuff. And again, just leave your notepads here in the seats. You do have some things back there?
Yes, I do.
You do. You don't? When Mike comes back, let's switch.
Oh!
All right, please be seated.
Can I
Oh,
take just a 2-minute Western break before we?
give me 1 second and let
Sure.
Mike come out and let's get them released and then you can.
Why do you want a restroom break? Fucking nothing else.
What's that? Leave your personal phone number for one of the girls. Oh, sure. Let me think. That's the first time I've been asked that question, so let me think about that for a minute. Yeah, if you want to leave it maybe for Mike, and at the end when they're excused, then he can get it to you.
I'm going to close this, Sarah P. I'm going to close this. But I'll explain it now in a second. But I plan on closing this.
And Mike, they got some stuff back.
We'll see what happens next. I don't know what happens.
You have stuff in the back, just a black bag is sitting back in the back corner by the bulletin board on the floor.
Where the what?
By the bulletin board.
Okay. Just that one case?
Yeah, just a black. You go.
We're just gonna hold Mike. You're gonna hold on to that till after they're done. She obviously can't call you during deliberations.
Right.
Okay.
Okay, let me get his black bag, and
Yeah.
if you would just leave your notebooks here in your bag, it's okay.
Yeah.
So they should be teleported over, Sarah P, as well. We're going on to Stefan Diggs' trial next, lovely, which will be on the sports channel. So that's where we're going next. Just because this could go on, they've got so many charges to discuss. This could go on all night. And even tomorrow, do you know what I mean? But it could be done in like 2-3 hours. I don't know. So the Ohio one, I will play that another time. Maybe tonight, maybe tomorrow. I don't know. Whatever.
And Mike, I'm going to give you or somebody the instructions and the exhibits here in just a second.
Say. Well, I think that means it'll have to be tomorrow then. Lovely, if it's 2:27, because I think they've gone past 2:27 now. You vote not guilty. I should put a poll up. I'll put a poll up later, maybe. Actually, let's put a quick poll up. I can't really, because so many charges. Joe, I forget about it.
All right. We'll be in recess until we hear either. I would ask you to stay close in case there's a question or anything like that. And then just make sure that the clerk has your cell phone numbers to be able to call you back in if there's a question or anything. Don't go too far away. Okay? All right. We'll be in recess.
The problem is there's so many charges. Do you know what I mean? I think it could be found guilty of some, but the lesser charges. But I'd be not guilty on the murder charges and stuff like that. But I think they will possibly. You see, I agree with you. I think that's why he will be charged on some of the lesser, found guilty on some of them. I won't look across the board because the prosecution pissed me off. I hate the laws as well, because I just don't think that they've proven to me that that he carried a gun with intention of robbing people. We are always twins, me and you. But Sarah P wants to make us triplets. I'm happy to be in the middle of Sarah P and Josie. I'm happy to do that. It's not a problem for me. Right. I'm going to close this because this could go on for hours. I will keep an eye on it. And if anything does come up, I'll quickly make a stream and put it on. But our main focus now is going to be Stefan Diggs on the sports channel. Please mind your P's and Q's, your languages, but speaking about the trial is all good. If you don't want to go there, that's absolutely fine. But that's where I am going next anyway. Then depends on what time that closes, I might go and do something else, the Ohio one or wherever. So, right. This should take you all over there. If not, then fuck do I know. And that's the last time I'm going to swear for a little bit. So, you should be sent there, yes. All right. Fuck you all. I'm joking. I love you all. Not really. I don't love you all, but I love some of you. Right. I'll see you over there. See you in a bit. Bye-bye.